We're live.
Good afternoon. The Chair of Judiciary is momentarily presenting a bill at another committee and will be back with us shortly. But today is Thursday, February 24th, House Judiciary Committee's bill hearing. Members, please set yourself to mute and only unmute when I recognize you to ask a question. After a witness testifies, you may ask questions by selecting the raise hand feature on your Zoom window, and I will recognize members in the order they raise their hands. Witnesses, you will unmute yourselves when I recognize you to present your testimony. After you present your testimony and answer any questions from the committee, please exit the Zoom hearing room. At all times, members of the public will be able to view the live stream of this meeting. The live stream is accessible on the Maryland General Assembly's website. Per our 2022 witness guidelines, 3 of today's scheduled bills are new bills, and they will work on the 2-1 rule, 2 minutes for the sponsor and 1 minute for witnesses. 1062, 1195, and 943. All the other are new and operate on the 3-2 rule. So we're going to skip the chair's bill, and the order after that will be starting with House Bill 877, Departmental Bill, House Bill 1010, Delegate Kipke, 887, Delegate Bartlett, 1036, Delegate Charles, 564, Delegate Cox, 1062, my bill, 1195, Delegate Branch, 1141, Adams, and then a pair from Shoemaker, 943 and 947. So we will get started with House Bill 877. And I believe this is being presented by Andrew Tress of DJS, who will have 3 minutes.
Thank you, Mr. Chair, Vice Chair, and members of the committee. For the record, my name is Andrew Tress, Director of Legislation for the Department of Juvenile Services, and I am here in support with amendment for House Bill 77. This departmental bill would bring Maryland into compliance with the Federal Juvenile Justice Delinquency Prevention Act. What that means is all youth under the age of 18 would be removed from adult jails and held in juvenile detention facilities while pending trial. Now, the reason this is emergency legislation is because if the state does not come into compliance, we could lose up to $370,000 per year in federal grants. These grants help fund community-based initiatives, diversion programs, and youth public safety strategies. So these efforts are essential to promote public safety and strengthen our communities around Maryland. There are some exceptions. For instance, in certain situations, judges may require youth to be held in adult jail if, after considering certain factors, it is in the interest of justice to do so. So judicial discretion is left intact. Additionally, this bill will not have a significant impact on the department's operations. DGS is already equipped to supervise this population and accommodates the majority of youth charged as adults in juvenile detention today. In fact, DGS has done so since 2015, when the legislature allowed transfer eligible youth to be held in juvenile facilities rather than adult jails. Currently, youth charged adults make up about 60% of the juvenile detention population. So the department has been and will continue to manage these kids without an impact on public safety. Also, DGS is simply better suited and designed to do so in comparison to our counterparts in the adult system. And more importantly, this can all be done without exposing youth to the traumatic experiences that can be encountered while in adult lockup, which in turn will ultimately yield better outcomes for kids in our communities. There is a proposed amendment contained in the written testimony, excuse me. This would allow the department to focus on bringing jurisdictions around the state into compliance immediately, while the juveniles in the Youth Detention Center in Baltimore City already have sight and sound separation from the adult population and therefore are already compliant. Notably, this would not disrupt Maryland from meeting the required federal standards. Finally, a similar bill was introduced last year and passed unanimously out of the Senate. For all these reasons, DGS urges a favorable report on House Bill 877. Thank you for your time.
All right, are there any questions for this witness? All right, there don't appear to be. We have one person signed up in opposition, Vince McAvoy. No, Vince. Okay. That concludes the hearing on House Bill 877. Thank you very much. We are now going to go to House Bill 1010 from Delegate Kipke. There are 5 witnesses: Haley Rizkala, Jason Hawkins, Ann Geddes, Christy Blaylock, and Michael Gross. This one is on the 3-minute, 2-minute rule. So we can start with Delegate Kipke whenever he's ready.
Thank you, Mr. Chairman. Good afternoon, members of committee. I'm going to speak quickly to reserve my time for Jason, my constituent, who brought this issue to my attention. Very simply, what this bill would do is what the adult court does in the way of drug court and treatment. Right now, the state of Maryland spends millions of dollars a year ensuring that we have inpatient and outpatient treatment for adults. This General Assembly has done great work in that area. This bill seeks to expand that to the adolescent population as well. And Mr. Chairman, if Jason has joined us, I'd like to ask, there he is. Okay, Jason, if you could unmute yourself. That concludes my comments. I'll be glad to answer any other questions.
Hello, Mr. Chairman. Thank you for giving me the opportunity to speak. I'm here on behalf of my son, Bradley, and his struggles with addiction. And I'll be as fast as possible here because I know I only have a limited time, but sometimes I get a little choked up in this because this is pretty intense. In 2015, my immediate family and I lost my 14-year-old daughter and Bradley's sister to a 6-month battle with cancer. This started a downward journey for him that's culminated in residential treatment in Pittsburgh at George Junior Republic, a financial free fall for his mother, culminating in him moving 6 times and being in 6 schools in 5 years, along with a lot of other death that followed right behind it. The last place he was living was in an environment with relatives that exposed him to multiple different drugs over my objections of him not living with me. We've had him in the ER 3 times, once sending him to Shepherd Pratt Stabilization Unit, which they recommended outpatient because there is no inpatient for what he has, 1 overdose and 1 suicide attempt. From 14, we've tried to get him into state inpatient resources for help. The last center closed 3 years ago because it was defunded. We tried outpatient services with co-treatment for his mental health challenges with a heavier focus on his substance abuse. Finally, last April, he was recommended by his PO that he be admitted into Spring Grove Hospital for evaluation, typically a 4 to 6 week stay. He was there for almost 5 months, and I'll come back to why. Spring Grove isn't a facility for a case like Bradley to be a long stay. While in the facility, the level of medical care was borderline gross negligence. After speaking with the medical staff more than once about immediate notification when there's a medical issue, he fainted 11 a.m. in the morning, and I wasn't notified till 3 p.m. that day. These are just examples. In a second incident, he complained about abdomen issues, which he was given a CAT scan, and the med staff said there was nothing noticeable. Come to find out, on a Tuesday, I was notified by the medical staff due to pharmacy error. He'd been getting double dosed for ADHD medicine for months, and they knew the previous Friday. In that same meeting, it was discovered that he also had a small lesion on his liver. It ended up being non-cancerous. Side note: kids aren't being recommended to inpatient because the SA specialists, the substance abuse specialists, aren't told to do an ASAM assessment. If you don't know what an ASAM assessment is, that's the American Society of Addiction Medicine. It's generally standardized by clinicians to find out the level that a child needs, or actually in general, a human needs. Once assessed, Bradley was the counselor, the substance abuse counselor at Spring Grove did not do this assessment. It's not in their standard practice. Once assessed, he was over a 3.1, which is suited for inpatient. He was in Spring Grove for 5 months because the court ordered DJS and MDH to copay for inpatient treatment, regardless of whether Medicaid paid for it. An adult is able to get immediate services out of the state budget, but there is no help for kids because the head of MDH has a belief that outpatient is the solution, and it's not. So in summation, let's get to Marylanders sooner so we don't have to see substance abuse issues throughout their lives by getting them services so that another family doesn't have to go through what I went through.
All right, thank you very much. Next, we'll hear from Haley Rizkala for 2 minutes.
Hello, Haley Rizkala mistakenly put her name when she signed up for me. My name is Ann Geddes. And I'm also I'm testifying on behalf of Maryland Coalition of Families. And I'm here today to offer testimony in support of House Bill 1010. The continuum of care for adolescents with substance use disorders is broken in this state. There are very few intensive outpatient programs designated to serve adolescents. And most significantly, there are absolutely no residential programs for adolescent substance use treatment in Maryland that take Maryland Medicaid. Over the last 6 years, Maryland's 4 adolescent substance use residential treatment programs shut down, with the last one closing in 2019. One of the reasons for their closure was that DJS stopped sending DJS-involved youth to them who were evaluated to require a residential level of care. With the dramatic decline in census, the programs were no longer financially viable, so they closed their doors. DJS had adopted the policy that they could serve these youth in-house. Unfortunately, very few youth now are receiving the level of care that they need. I'll briefly relate one story of a family that I interviewed. Their 14-year-old son developed a serious substance use issue. Overdoses, hospitalizations, multiple suspensions from school for possession, a serious car accident while intoxicated, and arrests for theft took place over a few years. 2 counselors that he had been seeing and 2 intensive outpatient programs from which he was kicked out for failing drug tests all recommended that he receive residential treatment, ASAM level 3.5 or 3.7 level of care. Instead, when his court hearing came up, he was sent to Cheltenham. In his 6 months there, he received 0 drug treatment. He was released owing to COVID, and since then he has continued to use with no further help offered by DJS. We do not want the court to have greater authority to commit kids to treatment out of home. What we do ask for is that DJS step up to the plate and competently evaluate youth in their care and then provide them with the needed level of substance use treatment. At this point, DJS's hand must be forced to do the right thing by youth who are DJS involved, with the caveat that the courts should not be given greater authority to commit youth who are not found delinquent. We support holding DJS accountable for youth that are in their care. Thank you.
Thank you very much. Next, we will hear from Christy Blaylock for 2 minutes.
Good afternoon, members of the committee. My name is Christy Blaylock. I'm the executive director of Guidenzia. We are the state's largest nonprofit substance use disorder provider, treating over 4,000 Marylanders across our continuum of care each year. While our agency's programs are limited to treating adolescents on an outpatient basis, we recognize the need for a systematic approach in addressing adolescent drug use across our state. We are also the largest Health General Article 8-507 provider across the state. So treating adults in the capacity of substance use disorder and the criminogenic factors that lead them to incarceration is what we do and do very well. The majority of our clients that we see are coming in with patterns and histories of use dating back to adolescence and sometimes younger than the age of 11 or 12 years old. So we know that the passing of House Bill 10 would be a meaningful improvement, not only in public health, but also public safety, and really would put Maryland at the forefront of being able to reduce the recidivism among justice-involved youth with substance use disorders. Guidenzia's support of House Bill 1010 is premised on the fact that it pragmatically addresses gaps in care that decades of research on youth substance use and justice involvement have laid bare. The research has shown the following considerations. First, research shows that compared to peers, justice-involved youth initiate substance use earlier and are at a greater risk of not only experiencing poor health, poor mental health issues, and also social outcomes. 70% of youth that are arrested have had prior drug involvement. That's huge, and that's alarming for us as a state. Secondly, research shows that far too few justice-involved youth are accessing treatment they need, both before, during, and after already engaging with the criminal justice system. A 2019 study showed that evaluating the implementation of behavioral health services across 33 juvenile justice sites found that as many as 65% of those youth met the criteria for having a substance use disorder. 1 in 4 of those youth were able to access treatment. Finally, our research shows that failure to recognize and treat substance use in justice-involved youth leads to higher recidivism rates and traps them in the endless cycle of addiction. It stands to reason that youth engaged in clinically appropriate treatment and aftercare services have a decreased likelihood of relapse, reoffending, and rearrest, much like their adult counterparts. Gaudenzia appreciates the opportunity to voice our strong support for House Bill 1010. If passed, the implications of improving access to this uniquely vulnerable population would be of monumental impact for the state of Maryland and would improve juvenile justice outcomes for years to come. We hope that we can count on your support. Thank you very much.
We have one final witness, Michael Gross, for 2 minutes.
Good afternoon, Mr. Vice Chair and members of the committee. My name is Michal Gross, and I'm an assistant public defender in Southern Maryland, where I represent youth. As Ms. Geddes said, this system is currently broken. In 2015, there were multiple adolescent inpatient substance abuse programs. While often they were used inappropriately to treat youth who were using marijuana or drinking alcohol, there was always the occasional youth with real substance abuse needs. So in the following years, as each of those facilities shut down or closed their adolescent units, there was a warning by the Juvenile Justice Monitoring Unit. What happens when we have a youth who actually needs inpatient substance abuse treatment? Maryland agencies were not prepared for that eventuality, and they didn't ensure that there was a program that was certified to provide adolescent inpatient substance abuse services. There are still options available. There's a private facility in Maryland, but they don't accept medical assistance. They're willing to work with state agencies on a per diem basis, but state agencies are not willing to pay out of pocket. So youth who require inpatient substance abuse treatment are instead either sent home to outpatient substance abuse treatment providers or to lengthier programs that don't focus on substance abuse treatment, and sometimes they're sent out of the state of Maryland. I know this because I've seen this happen to a client. What happens is we get disparate treatment for youth without private insurance. When a youth with private insurance needs inpatient substance abuse treatment, their parents work with their insurance provider and find an appropriate program. I will end by saying we appreciate Delegate Kipke's leadership on this issue and Mr. Hawkins for his advocacy to make sure that this doesn't happen to any other child or family, and working to ensure that regardless of who provides their insurance, every youth has a chance for appropriate treatment. We do have some concerns that this bill would require juvenile court involvement to access services, but would be willing to work with the sponsor and with the committee to find a solution that focuses on equitable solutions for all youth who need substance abuse services. And I'm happy to answer any questions.
All right, we have 3 questions, Delegate Shoemaker, then Crutchfield, then McComas.
Thank you, Mr. Chair. This is for Mr. Hawkins, who testified a little earlier. Sir, do you know if the Maryland Judiciary, the court system, the Department of Juvenile Services, or the Maryland Department of Health currently use that ASAM assessment that you alluded to when you testified earlier?
Throughout the beginning of this process, when they decided to put Bradley into this system, and even before that, there was never a mention of this ASAM level until I brought it up. Thankfully, listening to a book on tape, and I went to the head of psychiatry at Spring Grove in his unit. So as far as I know, and Mihal may be able to expound on this, as far as I know, it's not used. And it's unfortunate because it's the standard.
Thank you, sir. One follow-up question for you, though. Do you know whether, based upon your experience here of late, do you know whether DJS or the Maryland Department of Health have a relationship of any kind with any kind of current program that addresses this dual diagnosis of substance abuse and mental health?
As far as I know, they do not. An example is the closest that Bradley got to, he was turned down by several inpatient services in the state for mental health. because they do not have a component of substance abuse. And Rika, for example, because of COVID, was not willing to take him off site, and the off site treatment would have been one AA/NA meeting a week. So he's now in Pittsburgh currently at George Junior Republic without visitation due to COVID. He may not get out till May. So, and I'm not going to digress here, but that means a year of his life is gone.
Yeah.
And really, honestly, it was due to the fact that DJS was not willing to come out of pocket, like Ms. Gross said, and the health department refused to answer emails and phone calls until they were threatened with contempt.
Okay, thank you, sir.
Thank you very much for the question.
Delegate Crutchfield.
Thank you, Mr. Vice Chair. This is to the sponsor of the legislation, Delegate Kipke. Just wanted to find out, have you had any discussions directly with DJS about the services offered and sort of, what you wanted to create with your bill?
I have. They've been very willing to communicate. My suspicion is it's about the money, and there's a lack of willingness to cooperate in bringing this resource into existence. I've been told that outpatient is good enough, but having served on the health committee and over the last decade dealing with all the different things about substance abuse, outpatient just ain't enough for certain people. And I think it's, I actually was shocked when I learned that we didn't have this resource in our state. When Mr. Hawkins came to me, I didn't say it to him because I didn't want to insult him, but I thought to myself, this can't be true. Somehow the system let him down and just didn't, he didn't ask the right questions or whatever. And then I started digging in further, and people have confirmed that we don't have this in Maryland. So the youngest among us that find themselves with a substance abuse treatment, you'd think those are the ones we really want to help. I would think that we want to help everybody, but certainly at the top of the list are adolescents that have a new addiction. And you can get access. There's not enough, but you can more readily get access to this as an adult through the criminal justice system than you can as a child. So my thought was, we need a juvenile drug court that has access to residential treatment beds where appropriate. And we could have that if we had the will. The departments, they say it would cost a fortune to do this, but they don't have to do it. They can contract with organizations like Audenzia, who testified, and others. But I do believe it's about the money.
Okay, and would it be sort of possibly a county, by county effort? I mean, is that, have you really looked into the possibilities around this? How could this be done? You mentioned organizations, social services organizations, but are there other sort of thoughts around just the structure itself? I mean, I don't know what they do currently, and maybe that's part of it. I need to understand what is currently being done. And then, how do you, make that process better, or which is what it sounds like you're attempting to do here, is to really get to the root of the problem.
Yeah, I thank you for your question. The only place I've seen more access, I think, I'm learning that Prince George's County seems to do a better job with this on their own. But frankly, we have a statewide program for adults through the criminal justice system. I believe we need a statewide program for adolescents. And certainly the numbers of adolescents that are going to fall into this category is much smaller. I think you can serve the majority with outpatient treatment, but I think the ASAM evaluation is going to show a much smaller population really need that heavier level of treatment. But certainly it exists, and I mean this is a real way to change somebody's life, get them on the right track. So I appreciate your care and concern about this subject, because I don't deal with the things that you deal with. I can tell you all day long about insurance regulation, hospital regulation, being on HDO all these years. But I'm really interested. I hope you and others on the committee will really dig into this, because it was a real eye opener for me.
Okay, and I just have one other question, Mr. Vice Chair. And that is, I noticed that there was an unfavorable written testimony from the judiciary. Have you seen that at all, Delegate Kipke?
I did.
Okay.
I haven't.
And how do you respond to that? Because that is really the kind of the bulk of this, is that we're now into new territory with the juvenile jurisdiction, because now you're adding to that. So anyway, do you have a response to that yet?
There's two pieces to their opposition. The first piece I can't speak to yet. There's got to be a right way to make this work. And I this isn't my area of expertise. I just know it needs to get done, and it's of a high priority. The second piece of their opposition is the cost. And
Yes.
We got to figure it out. I mean, even if we were to shift some of the money that's currently going to adults, I think the priority should be adolescents with severe substance abuse problems. And in addition to that, it's going to be a fraction of the population of adults anyway. So it's a much smaller universe of people that are going to need this. And, the public defenders have expressed a real desire to improve this area. And it's obvious that it's a problem that needs a solution. And I seek the assistance of people with expertise on this committee and beyond to get this corrected in our state.
Okay, thank you, Delegate.
Thank you.
Delegate Crutchfield and Mr. Vice Chair, if it's okay if I can jump in and just respond to one of Delegate Crutchfield's questions.
Sure.
Okay. Delegate Crutchfield, you asked earlier about how this is dealt with around the state. And I will say that I did survey my colleagues to find out what happens when they have a client who has a recommendation for inpatient substance abuse treatment, but we know that there isn't adequate services for adolescents in Maryland. And what I was told is that, every time that this has come up, and it doesn't come up often because most adolescents don't require inpatient substance abuse treatment, but when it has come up, almost every single time they were able to find a way for either the parents to pay out of pocket or private insurance to pay for it. The situation that Mr. Hawkins is speaking about, however, is different because we're not talking about somebody who had the insurance or the means to pay out of pocket. And that's where the need for Maryland state agencies, whether it's the Department of Juvenile Services, whether it's the Department of Health, to pay out of pocket, that's where a solution comes in. There are programs available, they just don't accept medical assistance.
Delegate McComas.
Thank you, Mr. Chair. What I find kind of interesting is in my practice, a lot of times the folks that had lots of problems with substance abuse started out bathtub gin or marijuana as a teenager, and it developed into real problems, like 10 DWIs or, the majority of their life in prison. And so I would think that the sooner we get to these kids, the better, so that we're not, turning out people that cannot be productive adults and are basically being institutionalized. So with that said, are there any other programs that we could that would be near Maryland that we could send the children to in the meantime before we get our act together? I know in the old days, and I seem to be getting older and older, one of my husband's cousins worked at Shepherd Pratt, and she worked in the juvenile section. And sometimes when the children needed to, they weren't under the juvenile system, but they would ship them out to maybe Massachusetts or something for specialized care and treatment. So, and I'm not advocating that because that was obviously very expensive, but it seems like we ought to look at, well, obviously Pittsburgh is taking care of Mr. Hawkins' child, but at least until we get something in state, because I just feel like it's a real problem because and then when we legalize marijuana, I think we're going to see an uptick in problems too. So But I think if we could at least do something in the interim, is there anything possible we could do, the surrounding states, to work with them to get a compact or something?
Could Jason answer that question, Mr. Chairman?
Okay, thank you. Thank you for that question. That's actually an excellent question. And although Michal is not able to comment on this, she does represent my son. And she's done exhaustive work along with the resource officers from 2 different counties to find something suitable for substance abuse in the local state. And the closest one was Pittsburgh. Nothing in Delaware,
Wow.
nothing in Virginia that accepts that accepts Medicaid in the state of Maryland. And as Michal alluded to, the state agencies, although there is a state fund for adults to pull out of in this case, there is not a law that allows money to be pulled from the state fund for adolescents to go to a out of Medicaid contract. I don't know if I'm saying that correctly, but an out of Medicaid contract facility, whether it's in the state of Maryland or out of the state of Maryland. And we've done almost, even before Michal was involved, it was at least a year where we were doing our own research and we just kept finding out that things were closing, things were closing, things were closed. So that's an answer that I have. So thank you so much for your question.
And I can add to what Mr. Hawkinson said and say that I spoke to the insurance providers, specifically medical assistance insurance providers. And when they did a search through their program, one, they came up with an option that I knew had closed their adolescent inpatient beds unit. And so we called them together so that they could confirm with me over the phone. Their information was out of date. And then the other information that they had, the closest program was in New York State for a substance abuse treatment program that accepted medical assistance.
Just a quick question. With Hopkins and the University of Maryland and the School of Social Work, I mean, I'm just really surprised that there isn't something, in Maryland and leading edge, and also the public health, at Hopkins. I don't get it. I mean, do they know? I mean, has anybody hit them over the head and said, hey, this is something we need help with? I'm just asking. It's like, wow.
Delegate, I can actually answer that question. They are very concerned about mental health, which they should be. The problem is that they're lacking the comorbidity treatment is not available in this state. There is a company called Sandstone, a facility called Sandstone that just moved into the state that does this in other states. And from what they said, it's very successful. And you said something earlier. I just want to wrap it back around to you real quick. It'll be less than a minute. You said that we need to get to these kids earlier and that there's a gateway drug happening. Of course, it's the situations behind the drugs, but how often are drugs and alcohol involved in deaths in adolescence? 50% of suicides involve drugs and alcohol, and that's cited by the NIH. I'm not just pulling that somewhere. Where does Maryland rank in cause of deaths in adolescence? Where does that rank? It's the second lead. Suicide is the second leading cause of deaths ages 10 to 24 in Maryland. And in AA County, just recently, the girl suicide rate in adolescents raised 30%, and boys are 3 times as likely to kill themselves. So I just want you guys, please, to sit with that for a second. Drugs and alcohol are almost always involved in a child's death.
All right.
When it comes to suicide.
Got it. Delegate Erican.
Thanks. Mr. Hawkins answered one of my questions, but yeah, this actually happened in our family. We had a minor child who needed treatment, and the child ended up 14 hours away. 14 hours away. So thanks for bringing this bill, Delegate Kipke, and Mr. Hawkins. I'm so sorry for what you've gone through.
All right. And I believe that's going to be a wrap on the bill hearing for House Bill 1010. Thank you, everybody. Do we have the chair back yet? No. Okay. We're going to go to House Bill 887, Delegate Bartlett. There are 1, 2, 3, 3 witnesses favorable: Dorothy Lenig, Lisa Jordan, and Melanie Shapiro. And this bill is on the 3-2 rule. So Delegate Bartlett, 3 minutes when you are ready.
Thank you, Mr. Chair. For the record, I'm Delegate Sandy Bartlett, representing District 32 in Anne Arundel County, and I present to you House Bill 887. It's an opportunity bill for domestic violence victims. A protective order is a piece of paper, albeit it's a powerful piece of paper, but where's the importance what is the importance of a powerful piece of paper without enforcement? Pro se petitioners need the ability to get back in front of a judge, period. Not sometimes, but at any time where there are circumstances that result in a victim fearing for their lives or any other circumstances. We don't have any other mechanism other than a motion to modify or a motion to rescind for a domestic violence victim to get in front of a judge if they have a final or permanent protective order. And you may say, well, what is a judge going to do? Or you may look at the Judicial Council's testimony and you say, well, we already do that. No, we don't always do that. And we need to always do that. And the power is not currently in the hands of the petitioner. Pro se litigants don't always know how to craft a linear and a sound legal argument. And when it comes to something like trauma, after sometimes pro se litigants are receiving their protective order, after a week or days of extremely traumatic injury, and to expect them to be able to necessarily formulate an argument and to know what to do next and how to approach a courtroom, I think is an injustice and something that we can fix. This bill is intended to aid pro se petitioners, like I said, who have a final protective order, and it gives the authority to the victim. And so this, as I mentioned, the final protective order lasts a year, or in some circumstances, it can be 2 years. What is needed is a status hearing, the opportunity to get before the judge. The main purpose of a status hearing is, and it's meant to be broad in nature on purpose, because the main purpose of a status hearing is to report to the court with an update on any progress or failures made or on a previously identified important issue, and to determine the next best steps. The issues at the hearing depend on what's happening in the case and mandates, and how they're looking at previous mandates that were raised by the judge. This bill is necessary. In a DV case, it is not enough to rely on courts to call for a status hearing, as a Judiciary Council suggests. Who knows the conditions of the parties better than the parties? Who knows the fear of the victim better than the victim? The judge? In May of last year, across the street from my house in a quiet neighborhood, trauma came and will forever be present. My neighbor asked for a protective order against her former boyfriend several times, and he received a final protective order, but he also promised that he would kill anyone associated with her, and unfortunately, he fulfilled his promise. That evening, he shot her, her son, and he shot her son, his wife, and their 10-year-old before killing himself. My neighbor's adult son did not die immediately. He was able to get out of the house and drag himself to a next door neighbor. He died at that neighbor's side door. The 10-year-old lived after being shot multiple times, but he has been permanently, physically and emotionally scarred, and he is now an orphan. The bill does not fix every problem with DV cases. I wish we had that power. You will hear testimony that confirms what our power is and that we have the power to do more in DV cases, making the language understandable for an everyday person, especially the pro se litigants. And in January, just to note, in January, 2/3 of the litigants who brought a request for a protective order or who responded, 2/3 were pro se in protective order cases. So I request a favorable vote and listen to the experts. Thank you.
Great. Next, we'll have Dorothy Lenig for 2 minutes.
Good afternoon, Mr. Vice Chairman, members of the committee. My name is Dorothy Lenig. I'm the director of the legal clinic at the House of Ruth. First, I want to thank Delegate Bartlett for bringing this bill. We're here today to urge a favorable report on House Bill 887. If a respondent violates a protective order, there are really two ways that the petitioner can go to deal with that. For certain parts of the protective order, the no contact, the no abuse, the turn over your gun, those all have criminal penalties. And so if the petitioner wants to do something about that, the petitioner can file criminal charges. But for some of the other parts, the custody, visitation, emergency family maintenance, the pet, the car, those kinds of things, the petitioner really would have to file for contempt or for a modification to address it. The problem for a self-represented litigant is that contempt is unbelievably complicated to navigate. It's really complicated for unrepresented folks, but it's also complicated for attorneys and judges. And I think this was made really clear last fall when the Court of Special Appeals actually overturned a judge's use of contempt, saying that they were misusing it. And so even if a self-represented litigant did file for contempt, it would not address the situation of a continuing violation of the protective order. So let's say, for example, the respondent is late for visitation or doesn't return the child over and over and over again. The court in this case last fall said civil contempt cannot be imposed to ensure a person's continued compliance, but must be withdrawn once the compliance is achieved. So it would not address that situation of this ongoing violation. In this situation, a status hearing might give the court the opportunity to monitor whether the respondent is actually following the order and try to address it then. I really think the main point of House Bill 887 is to give unrepresented litigants more access to the courts. I do want to address two things that the judiciary said in their opposition testimony. Yes, they are right. There are other remedies, contempt, modification, but as I said, those are very hard to navigate. But more importantly, they made the point that they were afraid judges would be in the position of giving legal advice to the parties. And I want to say, we're not asking for legal advice. I think the important thing is that the judge might be able to point the petitioner in the right direction. Most of these cases are heard, if I could just finish, most of these cases are heard in the district court, the people's court. The judge could refer the litigant to a domestic violence courthouse program like the House of Ruth or the Women's Law Center, to the self-help projects, to the online forums. Mostly this would give these litigants more access to the court. Thank you.
Thank you very much. Next, we'll hear from Lisa Jordan for 2 minutes.
Thank you, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault, also here in strong support of House Bill 887. Delegate Bartlett, thank you for your leadership on this and on so many issues regarding survivors. You've heard much of what I would say from Ms. Lenig. Civil protective orders provide an important option for sexual assault survivors also, and they're either in addition to the criminal justice system, or for many of our clients, they're really seen as an alternative. In cases involving groping, particularly on college campuses, often we have clients who don't want to pursue criminal charges. They want to have something in the civil justice system. In the same way that this committee and all of us are grappling with the racial imbalances and other issues with the criminal justice system, our clients are very much aware of this as well and really like to have that civil option. And the thing about these civil protective orders is that sometimes they work beautifully. The respondent complies and stays away. Sometimes they are not as effective, and Ms. Lenig has already talked to you about the times when someone can press criminal charges. House Bill 887 helps provide a middle road on some of these cases. Often abusers are like the child who comes almost to the line and then pushes to try to press that line. And House Bill 887 gives the survivor an option. And as an example, we had a case, it was up in a rural county on a college campus, and this perpetrator had molested our client, and he was ordered to stay away, but he was permitted ingress and egress to his college classes. And then he interpreted that as not only ingress and egress, but also being able to hang out in the quad in front of our client's classroom. And so it was pushing the line. He kept pushing closer and closer. My client did not want to press criminal charges. Contempt is enormously complicated. This option of requesting a status hearing and having the court understand what's going on and refine the orders to make it very, very clear and draw those lines even more clearly, it's a fabulous option for many survivors, and it provides them access to justice without forcing them into options that they may not want to avail themselves of. For those reasons, we ask for a favorable report on House Bill 887.
All right, next we'll have 2 minutes from Melanie Shapiro.
Thank you, Mr. Chair, members of the committee. Melanie Shapiro with the Maryland Network Against Domestic Violence, also here in support of House Bill 887. I too would like to thank Delegate Bartlett for her leadership on this important issue. I don't want to repeat what my colleagues have already stated. This bill will provide an additional resource and pathway for victims and survivors of domestic violence to access the courts. As an attorney, I could, if I needed to get into court and something didn't fit neatly into something, I would know that I could ask and sort of create my own motion. But that is not something that the vast majority of everyday citizens who are not familiar with the legal process and are seeking safety know to do. The request might not fit neatly into a modification or a contempt, so they might not even know that they have the ability to access the courts. And this type of a request for a status hearing is exactly what we think could benefit survivors. And I know that there's much debate and talk about protective orders, but understand the importance of protective orders. We just memorialized the 58 victims or the 58 individuals who lost their lives in 2021 as a result of domestic violence. 18 of those deaths had a denied protective order in the past year. And so we think that any access to the courts through the protective order process is beneficial to and can hopefully prevent future domestic violence deaths. So we thank Delegate Bartlett and urge a favorable report on House Bill 887.
All right, we got one question from Delegate McComas.
Thank you, Mr. Chair. I just want to know, and I asked this for the advocates. I know in Harford County, we have a self-help group down in the basement of the circuit court. And then we have the Sexual Abuse, Spouse Abuse Resource Center. And a lot of times the individual can call up and get advice, and actually they have someone that will go to court with you. So I'm kind of wondering if those things are in place in other counties, because there is a lot of information out there, as well as the district court provides the brochures about domestic violence. I'm just wondering if there could be more done, since the judiciary doesn't particularly like this bill. That doesn't mean it's gonna die, but I'm just saying that, what else could we do outside of this bill maybe to provide more education to the public?
So I'm happy to answer that question, Delegate McComas. The House of Ruth has staff in courthouses in Baltimore City, Baltimore County, Prince George's County, and Montgomery County. We are literally in the courthouses, and people can walk in and we represent them in protective orders. But some people walk right past our office and don't even know we're there. We have some luck with judges announcing at the beginning of the protective order docket that we're there, but we have some judges who feel like that's giving legal advice to people. So I think we're all over the place in that. The beauty of this remedy to me is, once a person already has the protective order, if they don't know about SARC, or they don't know about the House of Ruth or the Women's Law Center or one of those programs, and they're trying to get into court, it would give them a pathway in. It would be very sorry, I got muted. They could refer them back out to the local program, and that would be great. They could refer, they could walk into court and be sent back out to the House of Ruth for representation and a contempt or a modification. It's really just creating the pathway, in my mind, to getting the person services or help is the most important thing. Because the most important thing with the protective order is you don't want any further abuse. So it's helping the person stay protected.
You're muted.
What if, I don't know, do you all know how many protective orders are passed, like in a jurisdiction, so that you could file a follow-up letter with your card and your information if they hadn't used you?
So
I don't know if you have the ability to do that.
You can, from the court's website, you can see how many protective orders were filed in a year, but we don't have access to the name of everybody who filed. You could sit in the courtroom, I suppose, and write it down, but that would take a huge amount of resources. And they can't, they can't give you the protective order, like the interim or the temporary protective order, until it's served, because, well, you can't. So it's only, there isn't a good system to get the information back and forth. It would be great if we could, if law enforcement would give us all the petitions once they're served and we could reach out to people, that would be great.
There are some smaller programs. I believe the Hartley House in Frederick County does have that system, Delegate Comas, so they are getting notice of the orders, and so there is that sort of system. Now, that's of course a smaller county than some of the counties that my colleague Ms. Lennick mentioned, so I think it would be a much more difficult case, but that would be fabulous if we had the resources and we had that communication. Other states have tried that, and certainly, as I said, I know at least Frederick County and I think some other counties are also working in that direction. But as wonderful as all of that is, that doesn't really negate the need for this bill. I mean, this bill really provides a very clear point of access in those gray cases, or those cases where really the survivor knows that something needs to be done as a preemptive matter. They don't want to wait until they're abused. They don't want to wait until EFM isn't paid. They don't want to wait until the visitation schedule is not just violated by 20 minutes, but suddenly it's days of not returning the child. So it would allow the courts to provide more oversight, not in every case, but in the cases where survivors know something bad is going to happen and they need the assistance of the court. So this really lets the survivors have access and control to the courts that, of course, all of us support and pay for.
Thank you.
All right, thank you very much. Looks like the chair is back just in time for the unfavorable Vince McAvoy on this bill.
For 2 minutes, please. Mr. McAvoy? Committee just for a moment. I will have to step away again at about 2:30 and I'll be back again. So a little bit more of the vice chair handle a little bit. Mr. McAvoy for 2 minutes.
Thank you, Chair and Committee. I'm urging unfavorable to House Bill 887. We've talked about many times in committee the false allegations in Baltimore. The clerks down there call them the Calvert Street expletive, word we can't say. These issues increase the chance to jail someone, as the nickname hints. They could be jailed, detained, or subpoenaed under specious claims. But aside from false or frivolous allegations, I direct you to the excellent aggregated data of your former colleague, Delegate Louise Simmons, who found that half of all DV claims in the state were not followed up on and were likely frivolous. Also, you could visit GoCaps, their website, allow you to extract the data, and recently affirmed Simmons's findings. But more importantly, these bills seem to be brought every year, every other year, to extend existing peace protective orders. There are reasons to keep these issues current and relevant to the existing conditions. And these involve cases involving child support, involving domestic violence, involving child visitation, and involving your neighbor or what have you. This bill doesn't stop perjury. It doesn't stop people from going to People's Law and Women's Law Center and judges who they'll provide orders without full information. I've seen people, House of Ruth try to get orders when there was no plaintiff for these existing orders. And to Delegate McComas's question, in every courthouse, you will find brochures and info, even if there's no pro se group on site, explaining how they can work through this process. Again, some of these issues they didn't choose. Some of these issues they did choose. They did choose that boyfriend. They did choose some of these situations they put themselves in. And it's not the state's job to legally educate everyone. I just want to tell you, we have a bevy, a huge amount of supplies for people who really want to take into their case. What they should be doing is going back down, explaining that they have no exigent situation, get the ex parte, get things updated. That's the way to do this. So again, I urge on favorable. I thank you for listening, committee.
Other questions for Mr. McAvoy? Thank you very much. That concludes the testimony on House Bill 887. And we're going to go onto my bill, which feels a little awkward doing that, but that's all right. This is House Bill 861. Committee, this bill came to me from a practitioner in Anne Arundel County named Marla Zide, and we're going to hear from Josh Tabor, who works at the law office of Marla Zide here in a moment. But I'm going to ask staff, we have an intern here with us, a couple interns with us, and the intern actually put together a PowerPoint because this is it's a little confusing. So bear with me here for this. All right, so we're on House Bill 861, and go ahead to the next slide. All right, so we're going to look here on the left and see the key that we're talking about, biological father and mom, the child, that identifies everybody. Here we go. So A and B have a child, C. A leaves or B leaves. It could be either one, but whatever. In this case, the father leaves or pass away, or they divorce, they separate. A is no longer in the picture. So it's just B, in this case, the mom and the child. Go ahead. B gets married again to D. And they they get married again. So B and D are there with the child. Go to the next step. But B and D then separate. And so, but in this picture, C, the child, still has a relationship with D. Go to the next slide. C and D still have a relationship, and C wants to be adopted by D. D would have to get the permission of their new spouse, E, in order to be adopted by D. Delegate Charles is not on the committee and is already, looking shocked. Okay, so bear with me. So the thing in current law is the partnership of both D and E have to sign off for for D to enter into the legal parental relationship over the child C. What this bill would do is, please click, would only require the consent of the spouse between D and E to enter into the legal parental relationship between D and C. So what the bill is seeking to do basically is we have these relationships that grow up over time that are becoming more complex. The current law basically says if you're going to effectively adopt a child, which is what in this scenario under the current law line here, D is trying to do for C, it requires the consent of both D and E. Really, E doesn't have anything to do with it. It's just D that wants to adopt C. So the bill would allow for only D to give consent for that legal parental relationship between D and C. The other problem that this solves is you can't have three parents B, as you can see, is still on the right side of the equation and is still there. This doesn't create three parents, just creates stepdad and B.
Is there going to be a test on this?
So yes, completely. It'll be at a voting session near you. So I went through this with Marla Zaid. I'd like now if Josh Taylor would like to correct my work in some way, that would be fine. But I think we got it mostly right. But we'll hear now from Josh Taylor for 2 minutes.
Thank you very much, Mr. Chair, and good afternoon, committee members. Thank you so much for giving me the opportunity to testify in support of House Bill 861. To clarify the chair a bit, what the new law, or I should say the old law as it is currently drafted, well, I'll call this step parent, the spouse of that step parent actually has to join in on the petition itself. What this bill, House Bill 861, is designed to do is to remove the joining in feature of the current law. We are still asking for the consent of that person. However, joining in is actually, of course, a much different analysis than simply the written consent of the spouse of the petitioner. As noted, 5(3)(b)(13), which is the current law, currently states that, of course, if a petitioner is married, the petitioner's spouse shall join in. What we were trying to do, again, is to clarify that we don't need yet another party in this action, because as the chair mentioned, you cannot have three parents here. And because of that, frankly, it doesn't make sense to have that party join in. With that, and I think that an important part of this bill, as clarified, is that, and it's on page 2 of the bill, the paragraph may not be construed to confer any rights or impose any responsibilities of a parent on the petitioner's spouse. So I think that is a very important verbiage here, especially considering the case law in Maryland as it relates to de facto parenthood, that by consenting to this, both either the biological parent or the prospective adoptive parent are not conferring any rights onto this other person, presumably which is going to be the spouse. I think the House bill as drafted would be very helpful in practicing. I am a family law practitioner in Anne Arundel County and other counties in the state of Maryland. And of course, my hope is that we will have your support behind it. I'm happy to answer any questions as well.
There's no question this is a little bit more complicated than usual. And so I appreciate Mr. Tabor's help. I'm surprised I only made one little mistake. So that's fine. We have several questions. Delegate McComas.
I feel like Linda Blair in the exorcism. Anyway, my question is, what happens to dad A? Okay, dad's the biological dad. Okay, dad hasn't died. It's just A and B divorced, and then things trickle down. Where is he in this? Is he still responsible? Let's say responsible for the child support for the child way back when?
I'll defer all the questions to Mr. Tabor.
Thank you so much, Mr. Chair, and thank you, Delegate. For one, it depends on the situation. However, in general terms, outside of what I'll call a biological parent passing, there could be a termination of parental rights that is going concurrently with the adoption as well. So in this type of scenario, for an example, if I can give a brief scenario, a colleague or a prospective client is married. They get divorced. That person, they obviously have a biological child. That person then, let's say biological dad passes away. You then have a child that is still out there, clearly, with one biological parent. If that biological parent remarries, or the prospective adoptee stepdad remarries, it creates this, I'll call it, hole in the statute. It's very much a loophole. Whereas if that new spouse does not join in, that person does not have the ability to adopt. Again, I know I'm getting down the rabbit hole a bit, but to answer your question, generally speaking, bio dad in the chair's situation, or I'll call it diagram to the panel here, it would very likely be a termination of parental rights type of situation. So it's possible that they would not be liable for child support depending on the outcome of that.
So, yeah, so basically that biological dad's out of the picture through death, through prison, let's say, through termination of parental rights.
Correct. Either by consent, by way of,
right.
Adoption. Correct. That is correct.
Okay. All right.
Delegate Juanita Fisher.
Thank you. Thank you, Mr. Chair, and thank you so much for bringing this piece of legislation.
Don't lie. No, it's fine. I saw the pause there, and that's fine. And it's a terrible LSAT question, and I accept it. And it is kind of interesting.
It is interesting. It's definitely fun. I feel like I'm in family law again. Anyway, thank you, Mr. Tabor, for being here. I just have 2 questions for you. Just looking at the bill itself, I do think that the consent to and the consent to in writing on line 18 and 1 on the second page makes sense, because you would assume the other parent, the new partner to stepdad, they're married and living together. And so maybe there's like joint living, so you don't want the child in the home and the other parent didn't consent to it. So my 2 questions are, if the spouse of the stepdad to be or stepdad in adopting does not consent, there is actually no recourse for the person to get the adoption or done, even though you're just changing it to consent. If the new wife or whoever does not want to consent, they will not be able to, correct? Is that right?
I would agree. I do agree with that analysis. I think that obviously by changing it to consent to it is still a threshold question, that there is still some level of act that has to be taken. However, I think the difference between consent to and join in, of course, joining as a party to a filing is a different level of, frankly, input and time and a lot of other things than simply consenting to in writing.
Yeah, for sure. Thank you for clarifying that. And then my other question, which is like super wonky because I'm sometimes in estate stuff, is what happens with let's say there is no will. What happens in the inheritance scenario for this child with step-parent, consenting spouse who would be inheriting because now she's the new wife scenario? So the child, and also just to add more to you, Mr. Tabor, I'm so sorry. We're also assuming that stepdad doesn't have his own bio kids or her own bio children that are also going to be up to inheritance in the passing. Because once we all know in our committee, once you adopt the child has full rights as if it was a bio child in our inheritance and intestacy laws. So my question to you is, what happens with that in this scenario and in comparison with other children that the stepfather who wants to now adopt D may or may not have? And that might be an off the line conversation. So I apologize.
No, I'm absolutely. And thank you so much for the question. I think it's very interesting. However, with that being said, I think that the bill is drafted is part of the reason why they want that consent in writing. I think that this consent obviously has an impact not only on the immediacy of this is now going to be a child that is either presumably could be living with that person, visiting, or obviously, of course, part of that family. Part of that, obviously, as it is drafted with the consent in writing, is it could have an impact on a will or trust, or, essentially, as that person were to pass, what is going to happen with their assets. So I think it is a interesting question. I think that it is addressed in the bill, though, because perhaps part of that consent or the conversation that needs to occur is this is going to be legally no different than our biological child if a new spouse and stepdad, if we're using that, have a child of their own. And I think that it's important that, again, that it's in writing. It's not verbal, of course, because this is a big undertaking by all parties involved, including this individual who is going to be presumably very much involved in the prospective adoptee's life.
And then I hate for my follow-up question. I'm sorry, Mr. Chair. And then to add to that, if bio mom B dies, then stepdad is full custody of this child. Yeah. Right? I just wanted that to be clear. Okay.
If the adoption proceeds,
Right. The
Adoption
adoption
proceeds.
fine. New wife consented. She doesn't care that the other two kids are also, they're all going to inherit. We're there. And mom by OB gets hit by a car. That child is moving with them full time. That's your kid. There's no going back.
Correct. I think that it would be treated as if, as you know, no different than a biological child. I mean, if there's an unfortunate passing of the last biological parent, in this scenario, biological mom, by definition, the child will be in the care and custody of the prospective, adopter, in this case, stepdad. Now, of course, that doesn't mean that there can't be challenges, as many of us know, as it relates to custody by either grandparents or what have you. But I think that that doesn't have any impact on House Bill 861 as drafted. I think that you could have that, we have custody cases, of course, as everybody knows, every day. But I think that, yes, to answer your question, stepdad, who is now the adoptive father, would have custody of that child.
I knew it was going to get everybody to ask questions. I just knew that was what was going to happen. Delegate Shetty, then Cham, then Tolles, then Hal. Delegate Shetty.
Thank you, Mr. Chair. I love these types of bills that really make us talk through all these different scenarios and think through them. So thank you. This is kind of fun. And thank you, Mr. Tabor, for joining us today to help answer from a practitioner's perspective. Although I'm a lawyer, it's been a really long time since I studied both trust and estates and family law, and I don't practice. So I'm wondering if you can clarify again for us what the difference is between joining in and consent. And then my second question that's maybe a little bit more broad, big picture. And I feel embarrassed that I don't know the answer to this, but why is it that, we have, lots of different types of families throughout the state and country. I was raised by a single parent. Why can't the law recognize multiple parents? Or why doesn't it? Especially if under the current law, the three are currently recognized. And I think, as you all have both stated a couple of times, you can only have two parents.
Thank you very much for the question. I'll try to go in order here. One, the difference between consent in writing and joining in. Joining in, the way that I interpret the statute, and I believe the court does currently as well, is that you are actually a named party. If you are joining in on the petition, for example, it would be Josh Tabor and person X joining in on the actual filing itself, meaning that as a party to the case, in my opinion, you are then subject to appearing at the hearings, going through the process, potentially hiring an attorney. Presumably, I think it is a waivable conflict, of course, in the legal realm from the practitioner standpoint, but I think there's also a conflict of interest that you could have there that could be waived. But again, you're going through the entire process, meaning that you are start to finish going through the hearings, attending the hearings throughout start to finish. Consenting in writing is completely different. You are not a named party in the petition itself. Now, information, of course, is going to be divulged in the petition about this individual, and presumably consent to in writing would be an exhibit to the petition, but you are not actually a party to the case. What
does that mean? Like, other than actually being listed on like the filings and the motions and participating in person, what does that mean, and how is it different than the ultimate outcome that the bill would address?
In my opinion, as I read the bill as currently drafted, and the major reason for the changes, if I am joining in on the petition, I am doing so because then two parties are trying to adopt this child, which under the current law, as the chair noted, and I think it kind of leads to your second question, is under the current law, we cannot have three people or three individuals trying to adopt a child because the law, frankly, at this point doesn't recognize it. So I think it's convoluted in the sense that the law, 5(3)(b)(13) is saying that a party or the spouse must join in, but in reality, you're then creating a scenario where it's potentially not possible to go forward if there's still biological parents that are still living. Now, if they're not, then I think it's a different issue, and I think that it could very well be that the spouse and stepdad want to do so. But where you have a biological parent who is alive and caring for the child, it creates this situation that makes it literally impossible for this person to adopt this child or children, which again goes to your second question, which is, why doesn't the law allow it? I think that there are other states, is my understanding. I'm only barred, of course, in Maryland, so I don't know the law specifically, but other states have recognized that there can be more than 2 people that would adopt a child or children, which frankly could be something that our legislature can take a look at and maybe change, which could have an impact, obviously, on 53B13. But as of right now, which is we have to take kind of the bill as it lies, I think that we need this change to ensure that, as you stated at the very beginning of your question, it's 2022. Blended families are normal. This is very normal everywhere now. And to cut off, frankly, a person that loves a child or children because of this, I'll call it weird part of this law, I think could discriminate kind of across the board. And it's, as the courts always say, the best interest of the children control in custody cases. I think it should control here too. And it should be, if we can get more people involved to support a child, even if they're adult, I think it only helps in this situation.
Delegate Cham, then Tolson Howell. Delegate Cham.
Thank you, Chair. Delegate Shetty stole my thunder, asked the perfect question. I was trying to understand the difference between removing the join feature and the consent in writing. And I think it's clear as mud now. Mr. Tabor, you probably could have used a visual for us to explain that. But no, that was my question. So thank you very much.
Absolutely. Delegate Tolles.
Thank you so much, Mr. Chair. Well, this is why I don't like family law, because it's too emotional. But but I did do very well in property law in law school. So, but this is not a property law question. I just simply want to know if the biological parent, based off what Mr. Tabor mentioned, to your response to Delegate Shetty's question, so you're saying that with this bill, a stepfather or a stepmother can ask for custody with a new partner, a new spouse. Is that correct? So I'll take step one. They can ask for, if the stepmother, stepfather had another spouse, they can ask, or partner, whatever, they can ask for custody of this child.
So to clarify, I think that there's a difference between asking for custody and, of course, adopting.
Well, I'm sorry, let me use the correct words, adopting. That's step one. First question, they can adopt?
Correct. Yes, they can adopt.
Okay, so what if the biological parents are not deceased? Then you would not need to get consent from them, because you said it would virtually make it impossible if they are not deceased. What if they're not deceased? Would you still, where does that sort of permission or consent lie with the biological parents? Maybe, they are around, but maybe they're paying child support, maybe they're around, but what is their ability for consenting to the adoption?
So, and thank you for the question. It's a very good one. I think that let's say, for argument's sake, we have bio mom and bio dad, and bio mom is what I'll call the one that is willing to consent in this situation.
Mm-hmm.
There still needs to be termination of parental rights proceedings that are happening kind of in tandem with this, meaning that there is not just a signing off feature, as it relates to these children or child. There is a very specific, frankly, notice requirements, form requirements that this person who is really giving up their rights to this child or children are doing it on a knowing and voluntary basis, even beyond that. So part of our adoptions proceedings, a lot of times in this line of work, is the termination of parental rights. So to answer your question, is not simply that these two parties are consenting. I believe it's even a step beyond that. They're not only saying, okay, I'm okay with this, or this is what I want to do, but they're really starting with the process of, I'm going to take a step back. I am terminating my parental rights to allow this child to be adopted, or for whatever reasons they may have.
So, okay, so they're taking a step back and saying that they're going to terminate their rights, because currently because the current law is that you do need to say that you will give up those rights, right? That's the current law.
It could be either by what I'll call consent, meaning that they are not necessarily fighting the process. They're
right. Or you can't find them if it's saying someone, they're trying to adopt and when they're a baby. I think the current law is that if you can't find them, then they've given up their rights if you try to locate them and give notice and so forth, right?
So there are not either, whether it's at birth or even later on in life, notice requirements where essentially show cause orders are issued for this person who, obviously we're talking about consent, but let's take the scenario whereas biological mom or biological dad really can't be found, or they just haven't been involved, let's call it for a decade. Notice requirements where you have to try to get this party served, that they issue show cause orders before they go through this process of terminating their rights, because of course, as the high court has ruled, your kind of fundamental right to parent is still paramount here. So it is not just easy that you can kind of, sign away in the consent scenario or, just proceed without them. There are very specific avenues that have to be met in the court system to terminate those rights. So it can either be by consent, or there are times when the termination of parental rights are contested, and the court could make a decision, which of course kind of bleeds into this bill. But hopefully that answers your question. There's two routes that could happen after termination.
I guess in closing, Mr. Chair, I guess my concern is that you could have a parent that's, say, in the military, been out of the picture for a while, or, maybe they've been, they could have, we've had the last bill about mental institution. They could have been, not well, and they maybe they moved, maybe, like I said, they've had some challenges, maybe they are in and out of the child's life, but will it be a problem? Will this pose a problem? Say they found again, but they didn't receive the notice, and then all of a sudden their parental rights is gone. Could that happen under this bill?
And if I can answer, or sorry,
rights will be terminated.
Mr. Chair. Thank you. And again, very good question. I think that it is a situation that obviously can be addressed on a case by case, but I think we need to take a step back to look at what is the purpose of this bill, right? So laying out the scenario that you just had, whether they're in the military or they've come back and said, I want to parent now. The changes in the current draft for House Bill 861 have no impact, meaning that scenario can happen as drafted currently. The only difference that you have there is that the new spouse is joined in the petition rather than consenting to the petition. So I think that it is a great question, Delegate. However, I don't think that this change in the law that is being proposed in House Bill 861 has any impact on that analysis. I think that can happen drafted now, or the way that it's going to be drafted, or presumably, hopefully, will be passed.
Okay. Thank you, Mr. Tabor. Thank you, Mr. Chair, for indulging me.
Oh, that's all right. Delegate Howell, your question.
Thank you, Mr. Chair. Mr. Tabor, my question is, in the case of an adoption, and let's suppose that something happens to the custodial mother who's in adoption, something happens to her, but then there's some consent needed for a medical procedure or something like that. What right does the biological father have? Does he have any rights here?
So I think, one, it would depend. Maybe I can ask for a clarification in your question. Thank you so much for asking. Are you saying after the adoption has been granted, does biological father have a right? Is that your question?
Yes. And let's say something happens to the mom, or even if something doesn't happen to the mom, and maybe the child needs a procedure done, a medical type of procedure, and it needs to be consented to. Does the does the biological father have a right to the consent for this procedure?
Sure. Thank you so much for clarifying. I would say at that point, the answer would be no. At that point, presumably, if the adoption is complete, that biological father in your scenario would have terminated his parental rights either by way of consent or by the court making a ruling on that. So as such, the rights to that medical procedure would, I'll call that legal custody rights, would cease under that scenario. And again, I think that the House Bill 861, the change that we're requesting would have no impact on that. I think that's how the law would operate currently under the current statute of 53B13.
Okay, thank you.
Thank you, Delegate Howell. Delegate Cox for the very last question, please.
Thank you, Mr. Chairman. And real quick, I wanted to focus on the consent aspect. Under the current law of consent for adoptions, isn't it true? I'm not sure who would be best to answer this, Mr. Chair, and maybe one of the experts. But
Mr. Tabor.
Isn't it true, Mr. Tabor, that if someone is imprisoned out of state, that consent can be had through a public notice at a courthouse in another state that the person that's imprisoned never actually has notice about? In other words, actual notice under the law of consent is not required under adoption law. Isn't that true?
Thank you so much for the question, Delegate. To be fair, I'm not 1,000,000% sure on this, but I believe you are correct. I think that as your example, kind of an alternative service type of measure or notice could be posting on the bulletin board of, let's call it, the Circuit Court for Anne Arundel County. Now, there's usually more notice requirements other than that, but I believe that that could potentially be one of them. Yes.
Well, thank you. And one of the most blessed things I've been able to do in my 17 years of practice is over a dozen adoptions. And I can tell you that one of the troubling things that I've experienced is the lack of actual notice before TPRing an actual father in a jail across the country. That bothers me. I don't agree with it. And that's my biggest concern with switching this to consent, I guess. But anyway, the other aspect, I guess, that chart, I'll be honest, Mr. Chair, I got lost at a point, and I think I still am a little lost on it, but my basic reading of the bill is that what this can do is that it can give standing to someone who doesn't have biological relations, but yet develops a relationship with the child apart from a biological parent. So in other words, someone that develops a relationship with a child would no longer need to have a actual biological petitioner with them to petition for their own standing for custody. Is that a fair understanding?
Mr. Tabor.
Thank you. And I think the answer is actually no. By the way that the bill is drafted, presumably, and this was a concern of mine in reading over until I frankly kind of dove into it. I think de facto parenthood is obviously relatively new in the state of Maryland, which obviously can create a relationship as it relates to a minor child with a non-biological parent. The way that this bill is drafted, and specifically it's section 2 that says, quote, "This paragraph may not be construed to confer any rights or impose any responsibilities of a parent on the petitioner's spouse." Pursuant to the new case or relative new case law in the state of Maryland, EN versus TR comes to mind off the bat. You have to have consent of both the biological parents to confer those rights as a de facto parent. So I think in the way that the bill is drafted, the answer would be no. You're not kind of setting this new spouse up in a custody battle or potential custody battle down the road. And to go towards your first point as it relates to notice requirements, which I can completely understand as to why there's a level of hesitation. Again, if you look at 53B13 as it's currently drafted and the proposed changes of House Bill 861, your concern as it relates to notice exists under the current petition the way it's drafted. This is just ensuring that, in my opinion, blended families have the ability to, frankly, adopt a child that they know and love. And I think that is the difference. While I completely understand the notice issues that you have, I think that those issues exist the way the bill is currently enacted.
Well, thank you. And since I have a bill coming up, I won't poke anymore at the chair's bill. So I probably already overstepped. But anyway, thank you very much.
No one has overstepped. No one has overstepped at all. And there is somebody to testify in opposition. I do have to jump off again. Here's the vice chair. Vice Chair Moon is going to take over here in a moment. But I do want to say thank you very much to Mr. Tabor, to Josh Tabor, for his going through this insane LSAT question from hell. And I would like to thank also one of the two interns that we have in the Judiciary Committee this year, Andrew, who is watching from home. And he set up the PowerPoint presentation that was very good, and at least mostly tried to cut through a very difficult issue. So thank you all very much for that. We'll hear now from the sole person in opposition, but I'm going to pass the chair over to the vice chair here for a moment, Vice Chair Moon, to recognize Vince McAvoy. So Mr. McAvoy.
Mr. McAvoy, whenever you're ready.
All right, thank you so much, committee. This bill actually has a lot of snags, and I think it's telling that folks some of you have done some family law, got a bunch of lawyers on the course, you are having problems with it. But I do think that I'm hearing some things that are disingenuous about this. This isn't a young biological dad's dying early bill, and there definitely will be child support. More to the point is the opening up of this type of bill perpetuating termination of parental rights. Now, Maryland already does this when it comes to incarcerated fathers, and that federal code allows for SENA, for instance, to move forward in placing a child. But let's be real, if you're talking about a third parent entering in and going through this, child support is going to be involved. The only way to get out of child support is death. So when you look at, for instance, Conover and the de facto case, let's look at the details of the case. They separate, right? So these type of bills, which are trying to mimic what was supposed to happen, they in turn fall apart. And so even though this diagram has A going down to B and C and E and F, this could go on and on and on. We've remembered Delegate May's bill, where she was bringing second and third parents, where they were trying to itemize how much child support was going to get. The most pernicious part of this bill is a possibility of a single parent of one person, and the bill would allow for this, to adopt. This must not happen. I'm going to be sending you all some literature later on today or early next week regarding the foundational part of having two parents, and that's why the code is thus throughout the country. I urge an unfavorable on this. If you have more detail, if you have more questions about these, because it can go in a number of different areas, and we only covered some of them here, even though there were a lot of questions. Understand that this is opening a hornet's nest of problems for a child where, remember in the Conover, child was 6 months. You're just making a mess out of what needs to be adhered to. Stick with the biological parents. You'll do great. Thank you so much for your time, committee.
All right. Are there any questions for this witness? Seeing none, that concludes testimony on that bill. We're going to go now to House Bill 1036 from Delegate Charles. And we have 4 people signed up in favor of this one: Vince McAvoy, Eric Smith, Marcus Anderson, and Christopher Anderson. It'll be 3 minutes for Delegate Charles when he is ready.
All right. Thank you, Mr. Chair, Mr. Vice Chair, members of the Judiciary Committee. For the record, my name is Delegate Nick Charles, and I'm seeking a favorable vote for HB 1036 So today you hear a bill on adding to the current definition of what qualifies a child custody case to be considered for an emergency hearing. Currently, there is no standard across the state. The only outlier and standard that deals with this is if the child is in danger. In its current form, the bill that I have before you will add if a child is being moved or plans to be moved over 40 miles away from the current address, which may interrupt the relationship and routine a child may have with the other parent. To put this in context, I'll give you a quick little story about how this bill came before me. I had someone reach out who had joint physical custody of their child, and the mother got a new job to move to Texas, and they both were here in the state of Maryland. She got a new job in Texas. He didn't want her to go and take the child to Texas, but she did it anyway. He files for an emergency hearing. The courts tell him it's not an emergency. He can't get an expedited hearing because the child isn't in danger. So he files the motion again, it's denied again. Then he files it again and it's denied again. 4 months goes by and he finally gets in front of a judge. And what the judge says to him is, if you would have got to me a little sooner, I would have been able to make a decision a little sooner on this hearing. By this time, a precedent had been set. The child is in a brand new school. The child is in a new doctor. And due to all of the movements, there was no violation of contempt that was put in place. And the child was remained in the state of Texas. And the father is becoming a summertime parent. And so what this bill has shown is that the unfortunate issue is that it takes about 3 to 5 months for custody hearings to take place once a motion is filed. And this creates an unfair balance. It creates a issue where a child creates a brand new routine. And this isn't changing anything outside of getting a hearing done a lot sooner than 3 to 5 months. In addition to this, there are going to be a couple of amendments that come to this bill. And the first amendment is going to add a pendente lite or custody contempt motion to be heard as an emergency or an expedited hearing when one party alienates the other parent from the child. And another is coming after discussion with the Maryland Bar Association's Family Law Division as far as codifying some of the family differentiated case management plans into law. And so each county has their own plan, and my staff did a case-by-case analysis. And one of the things that we found out is that currently under 4 different counties, Anne Arundel, Calvert, Carroll, and Cecil, this is already a standard practice within their courts that allow for this to happen. So this will codify this across the entire state so that these hearings can be held in an expedited manner. It's not going to change the outcome of a case. It's all based off of what's the evidence that's presented by the parties, and the judge will be able to make a determination. It just gets everyone in front of a judge a little sooner so that time doesn't go by too fast. But after this, I would like to pass my time off to some of the folks who are coming to testify in favor of the bill, and then I'm willing to open up for questions. Thank you, Mr. Chair, and thank you to the rest of the committee.
All right, do we have Vince McAvoy? I don't see him in the room. Why don't we go to Eric Smith for 2 minutes?
Mr. Chair, I'm sorry, I had a question for the sponsor.
Okay, we can do it that way. We're waiting, and we can try and get Vince McAvoy back in here in the meantime. Go ahead.
Thank you, Mr. Vice Chair. So I am proud to be a teammate of Delegate Charles and as a co-sponsor of this bill. When he told me the story, it was a compelling story. So I just had a clarification question. And I know we share the same constituents. Is this a Black father that was trying to get his child, spend time with his child? And
Definitely was.
Okay, I just wanted that point of clarification. And we did not want, he was trying to make sure he didn't have the court stop him from doing that. Is that correct?
That's correct.
Thank you, Mr. Chair. About delegation, Prince George's delegation. Thank you, Mr. Chair, for your work.
Thank you, Delegate Toles.
Thank you, Vice Chairman.
Right. Now we've got Vince McAvoy for 2 minutes.
All right, thank you so much, committee. Delegate Charles, thank you for bringing this bill. Nice bill, very important. When we have custody determinations, you would think that because this is amongst the factors, right, that Taylor and so forth are going to be looked at, that this would be reviewed every time, but this is not the case. And so what we have is we have unilateral parenting where you have situations where pockets of time are strategically work so that someone can move away with the child. There's a current case actually that even went to appellate court. I can never pronounce, I'm sorry, the Greek man's name. I'm going to do the best I can. Dino Karanikis had a very involved case, and here the mother went and moved to Pennsylvania. The court in this case had actually even looked at it over time, and this just shows the disregard that our judiciary has toward fatherhood, where they actually started looking at it in February and went ahead and approved a move in September the same year. This bill would help to get a hedge against those type of issues so that something can be started. Remember, a lot of times these cases come up and someone for the first time is entering into the legal system. They've never had any exposure to it. They have to learn everything on the fly for the love and society of their child. So again, I applaud Delegate Charles for bringing the bill, urge it favorable for it, and thank you for your time, committee.
All right, next we have Eric Smith for 2 minutes.
Yes, I am in support of this bill because I am I'll say victim of that. Hence, that's why my wife and I created Winning Strategies, Fatherhood, the Courts, and Custody. It is because a unilateral decision is made, and it's sometimes by the mother. According to the statute, a parent can't take a child out of the state unless they have permission from the other parent. However, then when you have biases from judges who give sole custody to the mother, this affects the entire situation. So basically, yes, I am in favor of this bill by Delegate Nick Charles.
All right, and it doesn't look like we have Marcus Anderson or Christopher Anderson. So we've got one question from Delegate Cardin. Go ahead.
Thank you, Mr. Chair. Just real quick, Delegate Charles, there looks like the current law is that with very limited exceptions, that custody or visitation proceedings, the court can include a condition of custody that you give 90 days notice, and within, if you get the notice, if you file a petition with the court within 20 days, the court must grant the hearing immediately. Why don't you just change the may to shall, that the court shall require 90 days notice, so that you don't have to basically create this whole structure of this 40 miles and all this other stuff?
Well, I put the structure of the 40 miles in place because, we're dealing, when you look at the state of Maryland, you can have a party who lives on the Eastern Shore and I didn't put it outside of the state, but you have a party to live on the Eastern Shore and then move the child to Western Maryland. And that's well over 3 hours to get from one place to the other. In the Washington metro area, somebody can move a lot further away from each other. If you live in, let's say, a part of Prince George's County and another person moves to Woodbridge, and if somebody is in the process of driving the child back and forth to school, we just wanted to make sure we had what the 40 miles represented was keeping it where it's not an impediment on the child and the time that's being spent with the other parent. So if that is a move that's taking place, allowing somebody to file for an emergency hearing or an expedited hearing. I think
Just
you're
to
on
follow
mute,
up,
Delegate Carter.
I'm quickly looking to see if there is unfavorable from the Maryland State Bar Association. You'd mentioned that, I guess, and from the Women's Law Center. Any other comments about that?
So when I spoke with the Bar Association, they brought up the Maryland Family Differentiated Case Management Plans. And my staff, we did a thorough county by county analysis as to what is out there currently and what are the practices by each county, and they vary so differently when you go county by county. And so what this at least does is, what they thought would be probably in the best interest would be to move to codify as much of this as possible into law. And so there's going to be an amendment that I'm working with the Bar Association to provide so that we have everything captured. So it just makes sense.
May I say something?
Go ahead.
But what this, it's just a violation of procedural law if they don't follow. So why would the bill just add something and just have the judges or the magistrates follow procedural law? And if they don't, then they are reprimanded. I mean, I can't hear you, Delegate Carter. I'm sorry.
I'm nodding because I'm understanding what you're saying. Thank you.
All right. Thank you, everybody. And we have one person signed up unfavorable on the bill, Michelle Smith. Do we have Michelle Smith in the Zoom room? Here we go. All right, Michelle Smith, we'll have 2 minutes when you're ready. Michelle Smith, 2 minutes when you're ready. You gotta unmute yourself.
I'm so sorry, Vice Chair. Thank you so much. I'm traveling right now, so excuse me for not being able to get my technology under control. I am Michelle Smith. I am here testifying on behalf of the Maryland State Bar Association Family and Juvenile Law Section Council. I have been listening, and I do agree with Delegate Charles' assessment that perhaps some tweaks to this bill would be necessary to have support from our section. Right now, we are issuing and urging an unfavorable report, but I appreciate the fact that the delegate reached out to me and to my section and tried to involve us and has been involving us in the process. What he said is true. Our concerns are that this bill is not quite able to accomplish the goals that the delegate is setting out to accomplish. And that is because, as Delegate Cardin pointed out, the bill is very specifically put into a section of the law that only relates to people with court orders that have mandated the 90 days of notice. So there's lots of other families that don't have court orders because they've never come to court yet, or they have a court order that doesn't mandate the 90 days notice because they negotiated a settlement on their own and they just didn't put that in. So we don't want to leave all of those people out in the cold. We want everybody to be under the same umbrella. Now, to change the law to require a across the state unified approach to differential case management plans is a laudable but ginormous undertaking. So we will work with him on that to see what we can accomplish, or maybe some tweaks to this bill with the amendments that he spoke about. The section has no problem with the idea. We all, as practitioners, have butted up against these problems where one person relocates, there's not enough notice, and the court system grinds along slowly, especially during COVID, and you're not able to get into court in a timely manner, and then things become status quo that nobody expected. So we understand the problem. It's just the tools of getting it done that we think needs some changes. So that's why we're recommending an unfavorable report to House Bill 1036. Thank you so much for your time.
All right, any questions for this witness? Gotta be from the committee. All right. Well, that's going to end the hearing on House Bill 1036. Next, we're going to go to House Bill 564 from Delegate Cox, and there are 5 or so witnesses on this one. 1, 2, 3, 4 favorable: Karen Merwin, Vince McAvoy, Eric Smith, and Tim Burkmeyer. One person signed up unfavorable, so we'll take those. It's a 3-minute, 2-minute bill, so 3 minutes per Delegate Cox whenever you are ready.
Thank you, Mr. Vice Chair, and thank you, committee. For the last 2 years, committee, as we know, the courts and many times have been closed, particularly the family law courts, to the public. And during that time, the coronavirus was misused by warring parents seeking to deny access and parenting time to the other parent based upon their viewpoint of how the parents should parent regarding the coronavirus, everything from testing to vaccination. So this bill simply levels the playing field and says that that issue should not be and may not be used in the best interest factor test that the courts utilize whenever discussing or examining child custody. When parents have difficulties in their relationships, their children often suffer. And this bill is a pretty straightforward bill, prevent illnesses from being used to deny child custody or visitation. That's currently the status quo. I'm going to talk about that in just a second about the custody factors, but the Center for Disease Control asked the National Academy of Sciences, Engineering, and Medicine, which is also NASEM, to review published information on parenting. And the committee found that several things that support a child's healthy development, like showing warmth and sensitivity to others, also include successful programs supporting the development of the children where parents are treated as equal partners in important decision-making. This addresses trauma, and involvement of fathers as well as mothers is very crucial to child development and to reducing trauma. The illness of a parent can be viewed as trauma enough without it being used as a weapon by the other parent. And that's exactly what's gone on for thousands of Maryland families in the last 2 years, sadly. Such behavior does not serve the children well, and it goes against several of those things that NASEM found to benefit child development. I respectfully ask for a favorable report. And I want to end on this point. The opposition from the State Bar Family Law Division is completely unfounded, misguided, and without factual support. The child custody factors, as family law practitioners as such as myself know, include at least 10 factors set forth in the law that focuses on fitness of a parent. It also is permitted to focus on the actual health of a child, but at no point is the parent's health allowed to be a factor in denying access to their own child. The only way that this is something that the courts look at is when the parent is unable, or has some other inability to provide actual care, custody, and control of the child. And that's exactly what my bill protects. So this bill, as you have it, is very clear that if any hospitalization is required, the courts can look at that as a factor, because obviously hospitalization can take a parent out of the field for a while in terms of the parent's ability to parent the child. But at no place in the law is a factor permitted to use whether a parent, for instance, has AIDS or any other condition, STDs. None of this is allowed in as a factor for whether or not they can see their child and have that parenting time. And also the 8 factors of the joint custody arrangement, same thing. The focus is on the child's communication. With that, Mr. Chair, thank you so much. We all want to protect our children, and the most important way to do that is to ensure that interested and loving parents have access to their children. Thank you so much. I urge a favorable.
All right, next we're going to hear from Karen Merwin for 2 minutes.
All right, thank you all for this opportunity to provide testimony. Delegate Cox, thank you for bringing forth this bill. I am with Family Reunion. It's a nationally recognized nonprofit that advocates for well-balanced laws that benefit families and, most importantly, children. COVID has already disrupted jobs, it disrupted the economy, our schools, and mental and physical health. Non-hospitalized COVID illness should not be a reason to deny a parent their right to child custody or visitation, nor a child's right to be with their parent. This bill deserves your support. It's no argument that many children deeply suffer from being the innocent victims of an often bitter and angry divorce between 2 parents they love. This bill will not allow COVID illness to further separate a child from their cherished and needed time with their parent. And that's good. Parents in court should look for any opportunity to help children thrive and have the gift of time with both parents who want to spend time with them. Divorce is often riddled with harsh feelings of resentment, anger, hatred between 2 parents who, out of spite, often look for any reason to isolate their ex from time with the children. They're the old common tools in the toolbox, so to speak, that a parent might use to keep the other from having their court-appointed time with their children. And now these past couple of years, as Delegate Cox mentioned, the excuse for COVID has become the new parental alienation tool. A parent's anger, spite, hatred, and control are under the disguise of COVID, and it needs to stop. And historically, I ask, has legislation ever passed that isolated a child from their parent because the parent has, say, a contagious flu? The CDC estimates in 2018-19, influenza caused over 35.5 million illnesses, the year before 41 million illnesses, yet that wasn't used as an excuse to deny parental time, but now COVID is. So this tells me, and I hope it tells you, that it's not about the concern of COVID illness. Rather, it's simply the new excuse used by one parent to further alienate the other from court-appointed time with their child, and it must stop. So please give HB 564 a favorable report out of committee. Thank you.
All right, next we'll hear from Vince McAvoy for 2 minutes.
Thank you so much, committee. I appreciate this. Delegate Dan Cox, thank you so much for bringing this much needed bill. It is very timely, insightful how you threaded this through. The separation of powers committee is why you should be looking at this from your perspective. If you're not entrenched in family law, what the judges, the Maryland Judiciary has done is taken on themselves to act sua sponte on an issue regarding expanding what would be permissible regarding a quote unquote illness. For some of these cases, and actually the one that I'm extremely familiar with, you're going to hear about today, there was no real conditions. It was expressed simply as a fear. But even the case that was brought up in Frederick and being used as a whip by the judiciary to deny visitation wasn't even a strong case there. And if you look through it, you can see the bitterness in that appellate case that rang through all the way. And this child was deprived of a youth pastor who's training others to come up and be fruitful citizens. This is unconscionable. But this really gets from the family law perspective down to the issue of where we are in Maryland family courts. I don't know, in 10 plus years, I have never seen not one serious attempt by a judge to make up lost child visitation. It doesn't happen in the state. That's why you must pass this bill. Whether we're dealing with COVID or the other issues that are listed in that part of the code, the fact is that our judges don't do right by our parents, and they let, as you just heard in the last bill, let unilateral decisions be made. The whole point is keeping it civil. They're just not doing their part. Again, they've stepped on your turf. You need to push back. You need to make sure that, look, if you want this in there, you'll go ahead and write it in there. It's not for them to do, but also, and as I say this every year, this gets to the corruption of our Maryland judiciary, who oversteps their bounds, denies the love and society of a parent, almost always the father, and there's no repercussions, even all the way up to our appellate level. So that's really where you need to step in. I would encourage you to look through my testimony, which has links to your previous colleagues talking on this very issue.
About it time.
Thank you, Delegate. And that we have had this instance looked at year after year and never addressed. This is one way through Delegate Dan Cox's bill that you can address it. I thank you for your time, committee.
All right, thank you very much. It doesn't look like we have Eric Smith here, so we'll skip over to Tim Berkmeyer for 2 minutes.
First of all, I'd like to thank Delegate Cox for supporting this bill, and also thank the chair and vice chair for the opportunity to come here today before you and speak on the extraordinary importance of this bill to all fathers in Maryland, not only to myself, but a number of other fathers that I know personally in the community. I'd like to share my story. In February 2020, it started out as a normal Friday. I was to pick up my son on a regularly scheduled time by order of the court, excited as always to begin our weekend together. I received an email message from my son's mother stating that she spoke with her attorney, and because of COVID now, she's suspending all visitations until further notice. This wasn't about COVID. Once again, this was another mechanism of alienation used by his mother to sever an extraordinarily tight bond. Over the next 9 months, the son who I raised every day of his life for the first 7.5 years of his life, I wasn't allowed to video chat with my son. I couldn't play video games. I couldn't mail him letters in the mail. I wasn't even allowed to speak with him through the window. At the same time, his mother had him going to birthday parties, 4th of July parades, bringing him out in public with other children. But as his father, I was completely cut off and alienated. What this bill would have helped me is when I brought my ex on charges of contempt, the makeup time, if there really is such a thing, the judge would have seen that there was no cause for the unlawful disregard of the parental time specified by the court order parenting schedule. So for almost 9 months, my son was completely alienated from not only myself, but the rest of his friends, families, and loved ones. And that's why, in my opinion, I'm favorable, and this is something that's very important, and we'll stop this type of alienation. Thank you. That concludes.
All right. Are there any questions for this panel? Delegate Crutchfield.
Thank you, Mr. Vice Chair. So to the sponsor, Delegate Cox, I am not a true practitioner in this area of child custody. I know that you are, and I know that there are, I guess, what I'll consider to be the enumerated factors for considering the best interests of the child. I know that safety is not necessarily one, but I do understand that judges do take that into consideration. And I would wonder and just kind of maybe ask you from the perspective of, what you have seen in that area of safety. I mean, we're talking about a communicable, contagious disease. And I know myself as a parent, I definitely would not want my child to be in a situation where they may actually come in contact with that. And I'm just curious about what you have seen as far as judges taking a look at the safety factor. Just let's take out the disease, let's take out everything else. But when they're dealing with the custody of a child, do they consider those kinds of factors, safety being the chief factor, in making sure that a child is in a good environment and where they will thrive and be successful?
Well, thank you, Delegate. And the first thing that we look at in the courts is the fitness of the parent. And the reason that that is the first factor that has to be weighed by the judge is because a fit parent has a 14th Amendment constitutional right to make care, custody, and control decisions of their children. That includes all medical decisions. The court has no jurisdiction to make safety decisions regarding medical decisions. The only time that can be overcome is when a parent is unreasonably denying lawfully needed medical treatment for a severely ill child. And we've seen that in the case law with certain religious and other decision making. Has nothing to do with regular case law in terms of medical decisions and issues where you have, whether it's a pandemic or whether it's a flu season or whether it's a more serious disease, like I mentioned earlier, such as AIDS. The courts have been very clear that the fitness of the parent is the deciding factor. And when a parent is able and fit to care for their child, they're presumed under the law, which goes back, the Supreme Court says, to natural law as time immemorial, to say that the parent has the right to make those decisions, not the court. And of course, that goes in a custody situation to both parents. And so when there is a difference of opinion between the parents, the parent with the tie-breaking vote tends to make the final medical decision, unless the court orders otherwise. And this can certainly create litigation in cases, but that's not the issue really. I think the depth of your question goes into very detailed litigation issues that's not really present in this bill. This bill's very clear and simple. It just says that you can't deny the lawful fit parent access to their child because you invent a safety concern in your mind. That's actually the reason why we have custody protection, because otherwise every single parent would do that. And I'll tell you an example. I litigated a case for 7 years where one parent was accused of Munchausen by proxy, where they invented, it was alleged by one parent that the other parent was inventing a medical concern to prevent access by the other parent. Turns out that's a mental case itself. Now it's not ruled under the DSM-5 as such, but it certainly became evident in court that both parents were misusing and weaponizing both mental health and medical information to falsely accuse the other side of a safety issue. So that's why this is a simple, straightforward approach that just says, look, if the parent's not in the hospital and the child's not sick, then the court has no right, and never did under natural law or our Constitution or even case law today under the factors, to interfere with the fit parent's decision-making.
So Delegate Cox, you're saying to me that the court would not look at the environment that the child is in to determine whether that environment is one that would, be one that the child could thrive in. If there's a safety hazard, if there's something there, are you saying that to me?
I went over the 10 factors, and I also went over the joint custody 8 factors.
Yes.
And the factors do not allow the court to enter into non-relevant information and to invent to itself powers to make its own medical judgments.
No, I'm not speaking to medical judgment. I'm just talking about the safe environment.
I think you are, because we're talking about COVID, right?
Well, I'm talking about so I'm taking COVID out of the picture for a second. And I'm just saying, do courts consider the safety of a child? Not necessarily because of a communicable disease. Yes, that's true. That's one element they could consider. But I'm just saying, just overall, do the courts also just consider the safety, that the environment has no hazards for the child?
Well, I know that in litigation, if there is a serious hazard that can be raised in court, but it's not a factor to be weighed unless it would demonstrate some kind of clear and present immediate danger to the child, such that would be illegal. Okay, we're not talking about that with this bill. This bill has nothing to do with that. This bill has everything to do with the irrational viewpoints of parties misusing a medical concern going around, whether it's the flu, whether it's COVID, or whether it's a ongoing permanent disease of a parent, to misuse that and weaponize that against the other parent. That's not permitted. And we need to make sure the courts stop allowing that to be used. And I think it's pretty clear. Now, when you have an illegality in the home, we all know what that looks like. That the law is very clear on that.
Right. No, I just wanted to understand environmental hazards, period, safety issues. Thank you very much, Delegate Cox.
Thank you, Delegate.
All right. That's appears to be the end of the questions there. We have one person signed up unfavorable, Michelle Smith. Let's see, do we have Michelle Smith? Yeah, let's go ahead and bring Michelle Smith in. Eric Smith is here. Okay, let's bring Eric Smith in. All right, Eric Smith. Sorry, we found one of our missing witnesses. Eric Smith, you have 2 minutes when you're ready. All right, Eric Smith, you can unmute yourself when you're ready. 2 minutes.
Yes, I'm in favor of Delegate Cox's bill because, yes, again, I have been the victim of that. Okay, when a magistrate ordered a evaluation, and it was found that the other parent had, I'll say, issues, okay? And it was the issues that were classified along with the disability here in the Maryland Family Law Code. And since I was acting pro se, I made sure that everything was on point, and the magistrate just totally violated it. And now we come to Delegate Cox's bill, and I feel as though this would try to, I'll say, alleviate the mishaps that have been done by the judges and magistrates. In this case, I apologize for having the earphone in because I'm at work, but that is my position, and I do support Delegate Cox's bill, HB 564.
Thank you very much. All right, now do we have Michelle Smith? And if so, can we bring Michelle Smith into the Zoom room? All right, Michelle Smith, you have 2 minutes when you're ready. And you got to unmute yourself.
Thank you, Vice Chair Moon. I was listening and it seemed like you couldn't find me in the waiting room. My name is Michelle Smith. I'm here on behalf of the Maryland State Bar Association, testifying for the Family and Juvenile Law Section Council. I would respectfully disagree from the Section Council's point of view with Delegate Cox's remarks regarding our written testimony. We do believe that every day in courts across our state, issues regarding parental health, the decisions they make regarding their own children's health, the stability of their own homes, the appropriateness of their own homes, all contribute to their fitness or unfitness in custody decisions that courts make. We do understand that there has been some very unfortunate issues around COVID recently in custody disputes. However, the language of this bill is so broad. First of all, it's in a section of our code that gives the court the ability to consider a disability of a parent if it finds certain factors and it affects the best interest of a child. But within that same section has been inserted language that refers to a disease or an illness of a party. It also says including COVID or COVID-like illnesses, but generally it says a disease or an illness of a party, which is very broad. And no longer will courts be able to consider those diseases or illnesses of a party if the party hasn't been hospitalized as a result, I guess. That is far too broad, and it interferes with the factors that have been set out over decades in our state that a court must consider in determining custody decisions with regard to what's in the best interest of children. As a matter of fact, I think it may actually interfere with what I understand now from Delegate Cox and the supporters to be the incentive behind this language. Because if the court may not consider that illness, it may not consider it as far as a parent weaponizing against that illness either. It literally is no longer a factor that may be considered in any way, shape, or form. So I think that creates an internal inconsistency in the statute. And for those reasons, the Family and Juvenile Law Section Council urges an unfavorable report for House Bill 564. Thank you.
All right, are there any questions? All right, Delegate Cox.
Thank you, Mr. Vice Chair, and thank you, Ms. Smith, for appearing today. Is it your opinion that someone that has COVID could be denied access strictly on that basis to their child?
No, that is not my opinion.
So would you be amenable to an amendment that simply allows for COVID and COVID-like SARS illnesses? Since you said that your viewpoint is it's too broad to include other illnesses, would you allow an amendment and then support the bill?
No.
And that's because you actually do agree that you do believe that parents should be denied based as a factor over COVID or SARS?
No, Delegate Cox, I specifically said that I do not agree with that. What I am saying to you is that if you would like to propose an amendment, I will take it to our section council. My individual beliefs on the subject matter are not relevant here.
I think you just said that you would not support the bill, but now you're thinking that you may be able to support.
No, that's not what I said.
You would not support the bill even with that amendment?
I've lost track of the thread of what you're even asking me at this point. So if you could ask it to me in a different way, what I am saying to you in answer to all of those questions is that if you would like to propose an amendment to the bill, I will take it to the section and we will issue our written testimony.
Well, what I heard you testify to is that you thought it should be and could be used as a factor in determining both fitness and best interest tests.
I don't know what the it is in that example, Delegate.
COVID or SARS related illnesses.
What I've said to you is that the factors are clearly set out over decades in our case law and that they must be considered by the court, and factors related to the health of the parties, the stability of their home are factors that are considered in custody decisions.
And so your testimony is that should continue inclusive of COVID-related illnesses.
What my testimony is that we have recommended an unfavorable report to this particular language that you have proposed.
And do you believe that courts should interfere with custodial access to their children because they have a disease from time to time that does not hospitalize them?
I don't think my personal beliefs are relevant here. I have offered my testimony from the section with regard to your particular bill.
I'm not asking for your personal beliefs. I'm asking for your appearance today. You're in a capacity of representing the Maryland State Bar or this section.
All right, we're going to move on to Delegate Cardin.
Thank you, Mr. Chair. Just very quickly, Ms. Smith, thank you for your testimony today.
I would just like to lodge an objection to being cut off by the chair.
Very well. Thank you. I think the witness answered generally the parameters in which she wants to answer this question. But we can follow up. We've got a long day ahead of us. We've got 5 or 6 more bills. Is that acceptable? All right, Mr. Cardin.
No, it's not acceptable.
Okay, Mr. Cardin.
Okay. Maybe I can ask a question, and that might draw you to another question, Delegate Cox. So if this bill passed the way it is written right now, if, for example, I had a daughter who was, say, 17 and pregnant, and the other parent lived at a place where everybody knew there were lots of mosquitoes and there was an issue with, and there was a big outbreak of Zika, for example. And this could dramatically impact her ability to have a safe child, healthy child, because of the risk to pregnant women. The courts could not consider my request to not allow visitation based on that if this bill passed. Wouldn't that be the case?
Delegate Cardin, thank you for that question. I'm not sure because I'm just pulling up on my computer the specific language of the bill again. I think it relates only to a disease or an illness of a party. So I'm not sure that your example would be foreclosed by this particular language.
Okay. So, and the child would not be considered a party, it would only be the parents?
Well, I think that's a good question. The parents are clearly parties against each other in a custody dispute. The child is sometimes considered a party, but not as often.
Could the child request like an advocate to go in and represent her as a potential party?
Sure.
And say, look, I can't go because, and then would have to get a judicial ruling if the parents couldn't agree.
Sure, there's lots of cases in which the children have best interest attorneys or advocate attorneys, and their voices are heard, or sometimes they even testify. Their voices are heard about the circumstance in which they are living in each home and whether it's safe and stable and in their best interests. And so that kind of health issue would definitely be a factor and should be a factor that's considered under all of our other factors. The particular statute that's being amended here by this bill deals with disabilities of the parents and circumstances in which courts can consider them. And I think that this language is just sort of being shoehorned in the wrong section. It's inappropriately amending this section.
Okay, thank you.
All right, that looks like the end of the questions on this bill. That ends the hearing on House Bill 564. Thank you, everybody. We are on my bill, I guess, House Bill 1062. There are 6 witnesses on this one. Lisa Radoff, Crystal Mowry, Jennifer Bevan-Dangle, Carolyn Ratliff, and Carolyn Griffin. I will hold and give a quick summary of this one. This is a reintroduction, so it's on a 2-minute, 1-minute rule. Let me get my own timer to try and keep myself honest. All right, colleagues, House Bill 1062, it deals with the cost of caring for animals when we're in a trial for neglect or abuse, essentially. And the fundamental problem here is that animals are not like ordinary property. And so while these trials, which often take quite some time to resolve, are happening, someone needs to be paying for food, shelter, and veterinary care for the animals. And it is often, if not always, going to be the taxpayers and the humane societies that are left with this cost while these trials are happening. In your packet, you should see some examples, and you'll hear more about this. Howard County, a 2-year case involving hoarding of 60 animals, cost over $500,000 during that period. Talbot County, a dog needed extensive veterinary care 5 months before the owner would agree to forfeit the animal, $1,800. Baltimore County, 154 animals in a hoarding case, $186,000, so on and so forth. We've had past bills on this that allowed the judges to directed them in some way to take take a look at this and try to start issuing these, but it's at their discretion. It's not a guarantee, and it happens essentially at the end of the case, which means, again, folks are still in limbo for these animals. And it also makes it difficult, frankly, if they need some mercy, to necessarily euthanize them if a vet recommends that, because again, the disposition of this as property is not necessarily going to happen until the end of the trial. So you'll hear more about this problem from the folks that come after me. My time is up. Trying to stick by the rules here. So next we will have Lisa Radoff for 1 minute.
Vice Chair Moon, members of the committee, for the record, Lisa Radoff, Chairman and President of Maryland Votes for Animals, here in support of HB 1062. You're going to hear a lot of testimony, so I'll just make a few points. 38 states already have cost of care laws, including all of our neighboring states, Pennsylvania, Virginia, Delaware, and even West Virginia. So passing this bill would not be having Maryland go out on a limb with new legislation. It would simply put us in line with most other states and all of our neighbors. HB 62 provides relief for animal control agencies and shelters facing fiscal challenges, as well as for Maryland taxpayers who would not and should not be held financially responsible as this case is being decided. I will be brief, as I said. How often do we get to pass legislation that is both compassionate, allowing for seized animals, if determined by their owner to be too much of a fiscal burden, to be adopted into loving homes? This bill is financially responsible as well as compassionate. By establishing a uniform system, all parties, including the accused, the animals, and the animal control agencies, are protected. Thank you, Vice Chair Moon, for sponsoring this bill again. I hope the 2020 is our year. Thanks so much.
Thank you very much. Next, we'll hear from Crystal Mowry for 1 minute.
Hi, thank you, Vice Chairman. I just want to elaborate a little bit on the written testimony that I've already submitted. I want to make some things clear. This bill only applies to animals that are seized as victims of animal cruelty or neglect. The following examples may be hard to hear, but it's the reality that we face. We're talking about animals that are suffering from starvation, living in hoarding conditions in their own urine and feces. Animals that have been beaten as a result have broken bones and other trauma, and yes, even victims of sexual abuse. This is not about barking dogs or animals running at large. That's a civil issue for which all jurisdictions in Maryland already have policies in place to address. Excuse me, the animals in this bill require money to heal them. The agencies need funds to pay their medical bills and housing. This needs to fall on the owner who refuses to surrender the animal. The owner wants to retain ownership during the trial process. They should be made accountable to pay for the animal's care at the time it's needed. The agencies providing care cannot wait till the criminal trial is over to pay all the medical bills and housing these animals need, and neither should the owner. The impounding agency also in a majority of cases has no option but to treat the animal. Euthanasia of a impounded animal can only be done when the owner consents, which they never do, or the veterinarian recommends it, which is very rare. One example is a dog my agency is currently holding for starvation. First 6 days, we spent $3,000 in an attempt to save her life. 3 different vets decided during that time she was not a candidate for euthanasia. Our agency was not given an option to euthanize due to the medical cost. If we have to pay this up front, the owner should be responsible too. I ask for a favorable report on HB 1062 and welcome any questions.
Thank you. Next, we'll hear from Jennifer Bevan-Dangle for 1 minute.
Good afternoon, Mr. Chairman, members of the committee. My name is Jennifer Bevan-Dangle. I'm the State Director for the Humane Society of the United States. Thank you for your leadership on this bill, and thanks to this committee for hearing us back in before you again, as Ms. Radoff mentioned. I want to stress a separate critical reason for addressing this piece of legislation. Since 2017, the status of dogs that are seized under our cruelty and severe neglect statutes has been in doubt and in limbo. It has left every county to handle and interpret these situations differently, and it creates uncertainty for owners and for animal control and state's attorneys. As the court said, the statute is unclear, but did not provide a solution or an alternative. This was the 2017 case of Rohrer versus Washington County, and that's a significant part of what this bill seeks to do in the first section of the bill, clarifying that uncertainty and making sure that there are clear statewide standards for dogs that are seized as a result of, again, severe abuse, severe neglect. And I want to reiterate what Ms. Mallory said. These are very severe cases where there is a high threshold that the ACOs are proving before they can take action. And once the action has been taken, this bill actually improves the process for owners by expediting the process, by having one hearing for both the disposition of the animal and the cost of care. And at that hearing, the preponderance of the evidence standard must be met. So this is a robust bill that is critically needed to clarify current law that has significant protections for owners. And we do urge a favorable report on 1062.
Thank you very much. Next, we'll hear from Carolyn Ratliff for 1 minute. You need to unmute yourself. Ms. Ratliff, you need to unmute your microphone. All right, we might have a technical issue there. Do we have Carolyn Griffin? Oh wait, Carolyn Ratliff, I see you've unmuted yourself.
I'm sorry, am I unmuted now?
Yep, go ahead, you've got 1 minute.
All right. Oh, well, Mr. Vice Chairman, members of the
you need to unmute your microphone. I think you need to turn your YouTube streaming audio off. All right, we might have a technical issue there. We have Carolyn Griffin.
I'm sorry.
Carolyn,
I don't know what's going on.
I see you've unmuted yourself.
I'm sorry. Am I unmuted now? Am I unmuted now?
Go ahead. You've got 1 minute.
Oh, well, Mr. Vice Chairman,
microphone. Mute this. YouTube. All right. Audio feedback loop there. All right. Let's see if we can get that resolved. In the meantime, let's do we have Carolyn Griffin with us? Okay, we appear not to. Well, why don't we do this? Let's take questions on this panel here, and then we'll bring up the unfavorable, and hopefully in that period we might be able to get the audio working for Carolyn Ratliff. But are there any questions for the first set of witnesses?
Oh, wait.
Delegate McComas?
Yeah, I talked to my Harford County Humane Society, and I know they've had a real serious problem with a lot of these situations where there's a hoarding situation and a number of animals are seized. And I wondered if there's some way that you can tell us how many hoarding situations we have versus just cruelty to one or two animals. Because it seems like the animals that there's a significant number of them are really expensive on the rescue societies.
Mr. Vice Chairman, I'm happy to answer that question.
Go ahead.
I was getting ready to jump in, sorry.
Oh, actually, Crystal, you're by far more.
So I'm with the Humane Society of Washington County. While we do have quite a few single cases, yes, we do have a lot of hoarding cases. Example, one that just made the headlines, I think everywhere, was the 112 animals. It was 92 dogs and 20 cats we just took out of one house last June. Yes, one house. And so we do have quite a bit of those. Just last year, we had that one. We had 36 cats from another house. Then we have groups of 10, groups of 12, which may not sound like a lot of animals, but when you multiply, you're going to estimate from, their conditions, at least $600 in animal and medical bills, including, if we get them to spay and neuter them. We have quite a few hoarding situations, but the one I just referred to with the starvation case, that 3,000 was just in the first 6 days to save her life. The bills were actually almost 4,500 by the time she had recovered.
And so there was no way to recoup that unless it was by donations for folks to help save the animal.
Yes, it is. And our agency is only funded for 54% by the county. So the rest we have to try to solicit and do, if I just may add, rarely ever do we get restitution. If it's granted, in my 9 years, I've had many tens upon tens of cases, and I've only seen the money come back one time. They just don't pay because there's no penalty for not paying it.
Well, I think the other thing is, at least in, I think Harford County's situation, it was pretty complicated, but I think nobody went in and asked for restitution, and there was no judgment. And I mean, it was kind of a mess, but anyway, thank you very much. I have one quick question of Delegate Moon. Delegate Moon, I looked at the fiscal note and they talked about the seizure of farm animals and everything. I assume that that's going into a different section, because I think that's getting deleted out of the animal rescue of regular animals as opposed to farm animals. Is that correct?
It's specifically worded. I wouldn't say it's deleted. It talks about,
okay,
herding dogs and livestock and what have you. So it's not a deletion. And let me also just clarify too, if the person in question who has custody or ownership of the animals doesn't want to settle the cost, they can relinquish the animal. The problem is when they're trying to have it both ways and then also don't want to pay for the care while they're forcing this thing to be dragged out. I just think that's a bit problematic, and that's really, I think, at the heart of what this bill is getting at. So, and I see the chair is back. Mr. Chair, we have retrieved one more witness that was having technical issues on the favorable panel, Caroline Griffin.
Caroline Griffin, and then Ms. Radoff is signaling there's a second person maybe who's having.
Yes, I think that Carolyn Ratliff might be able to.
Oh, I see. Both.
Yes.
Carolyn Ratliff and
Caroline and Carolyn. So two
yes.
ladies.
Okay, fine. So why don't we hear from Caroline Griffin, please, for 2 minutes?
Thank you, Chairman Clippinger
yes.
and Vice Chair Moon. Caroline Griffin, I am the former chair of the Baltimore Animal Abuse Commission and currently chair the Maryland Spay Neuter Board. I just wanted to raise 3 points. A decade ago, the ABA issued a resolution urging all states to enact cost of care legislation. And this came on the heels of the Michael Vick dogfighting case, and the Missouri 500, which was a large-scale dogfighting enterprise in the Midwest. And these cases brought to light the extraordinary burden on our shelters when these large-scale seizures take place. And since then, 38 states have enacted some form of cost of care. Our failure to do so is really hurting Maryland. The Animal League Defense Fund ranks Maryland 32nd in the nation in terms of the strength of our animal protection laws. And we're actually far lower than all of our surrounding states, including West Virginia, which is ranked 20th. And I pulled up the Maryland ranking this morning, and the first criticism is no provision for pre-conviction forfeiture of abused animals. It's right there in black and white. And finally, there is nothing unfair or inequitable about this cost of care provision. And in fact, it's very similar to what family law courts do every day. In a divorce case, if parents can't agree prior to trial, a court will order the non-custodial parent to pay pendente lite child support to the other parent. And that's because parents have an obligation to support their children, whether they live with them or not. This is a similar statute, and our failure to have cost of care is actually hurting the citizens of Maryland because it deprives our municipal shelters from fulfilling their mandates, which is helping all citizens in a county. So I urge you to issue a favorable report. Thank you.
All right, let's hear now from Carolyn Ratliff, please.
Mr. Vice Chairman and members of the committee, I go by the name of Nikki, that would be Nikki Ratliff, and I'm here today testifying on behalf of our State Association of Animal Care and Control Agencies and Organizations to ask you on their behalf to please give House Bill 1062 a favorable vote. Please know that many folks have worked over the past several years to better the cost of care bill, make it more fair and more clear while accomplishing the original goal of taking the financial burden off of Maryland taxpayers and those citizens who donate to Maryland's nonprofit animal welfare organizations, neither of which should bear the cost of caring for severely abused animals involved in a criminal case. Animals whose lack of care has risen to the severity of needing to be removed in order to be properly cared for or to in fact save their lives. The potential cost of care can come into play when making the decision to seize. That should not be cause for concern when faced with this decision. Animals should not suffer. Those protecting them should not have to make this very difficult and unnecessary choice. Currently, there are 7 private nonprofit shelters housing animals for animal control authorities. I personally have been in the business of protecting animals while assisting the public for 50 years. I recently retired from the Humane Society of Carroll County, where we were the enforcement agency as designed by our county commissioners. I've witnessed much neglect, some far more severe than others. Most often, we were able to work with owners to educate and correct the issues at hand. Other times, we were met with absolute refusal to do better for the animal in question. Seizure is seldom, if ever, a humane officer's first thought. And while I can't give you the exact numbers, my very well-educated guess based on my years in this field and my discussion with others would be no more than maybe 2 or 3% of the thousands and thousands and thousands of calls received across this state every year from concerned citizens. They don't, only 2 or 3% result in seizures. There are well over 200 animals currently being housed in Maryland shelters right now awaiting judicial disposition. Many of these animals have been held for a year or more. The cost of care, depending on the severity of the case and the numbers of animals under protective custody, can pile up in a hurry. Thank you for your consideration of this much needed bill, and I hope you'll give it a favorable vote out of the committee. I appreciate your time.
Thank you. Any further questions for the panel as a whole? All right. Seeing no further questions, we thank you all very much for your testimony today. And we'll hear from the one witness in opposition now, Charles Hall. Charles Hall. See him. Charles Hall, please. Charles Hall. Mr. Hall?
Okay, I was having trouble getting my computer to work properly.
There you go.
for a second.
We can hear you now. If you want to testify for 2 minutes, that would be fine, please.
Yep. User error. I apologize.
Okay.
Yeah. Hi, my name is Charlie Hall. I represent the American Kennel Club. And I'm here today not only to represent the American Kennel Club, but also our Maryland affiliate clubs and the thousands of constituent dog owners in Maryland to express some concerns that we have with House Bill 1062. And we understand the reasons and the purposes behind the bill. And in fact, we appreciate that the amount for the cost of care is limited to $15, up to $15, and the cost of reasonable veterinary care. Our concern comes in a situation when someone is found not guilty. We do realize that if someone goes through that entire process and they're paying the cost of care, and at the end of the day, they're found not guilty, they can get not only their money back, but also their animals back. Our concern stems upon the process where the individual is, because as was mentioned, these court cases can sometimes drag out for long periods of time. So at the end of the day, someone of little means could actually be just simply worn out, not guilty of anything, and even be found not guilty of anything, but because they missed a payment somewhere along the line, they are unable to get their dogs back. We believe that House Bill 1062 disproportionately impacts those with lower fixed incomes who may not be able to pay the charges throughout a long ongoing trial process. AKC believes that if the individual is not guilty, their animal should be returned to them and they should continue to be the owner of the animal, even if they miss a payment. As such, we would simply request an unfavorable report on House Bill 1062, absent language that protects the undeniable ownership rights of an innocent owner. Thank you.
All right, other questions for the witness? All right, seeing none, that concludes the testimony on House Bill 1062, and we thank you very much for speaking with us today. We are going to go now to Delegate Branch, who is here, Delegate Chanel Branch, who is here. There are 3 bills related to grandparent visitation. I think that Delegate Branch's is a reintroduction. Delegate Adams is new. And Delegate Shoemaker is a reintroduction. I'm hopeful that people can identify some of the differences between the bills as they begin to testify with them, but we will hear all 3 individually. I'm going to call a little bit of an audible. There are not many witnesses on each one of the bills. We'll hear 3 minutes from the sponsor, 2 minutes from everybody else. So Delegate Branch, if you'd like to begin with House Bill 1195 for 3 minutes, that'd be fine.
Thank you, Chairman Clippinger, Vice Chair Moon, and members of the Judiciary Committee. For the record, I'm Delegate Chanel Branch, and I come to you today to ask for your support for House Bill 1195 of grandparents visitation. I would like to start off by saying that I've amended this bill and it's no longer in its original posture. This bill, as amended, now will establish a work group that shall study the circumstances under which a court should be required or authorized to grant visitation rights to a grandparent of a child. As you may know, grandparents are facing challenges to be present and active in the lives of their grandchildren. The death of a parent, divorce, and separation have been the cause of disruption in the relationships between the grandparents and the grandchild. A study conducted at the University of Oxford notes that grandparents play a high-level role in the emotional and behavioral development of a child. Boston College has also found that an emotional close relationship between the grandparent and the grandchild is associated with fewer symptoms of depression for both generations. Grandparents tend to have the patience and the wisdom necessary to provide a stable foundation in the lives of their grandchildren amidst the disruptions in the family structure. They are at times a listening ear, a mediator between parents and children. They give sound advice when needed, and in some cases provide financial assistance to support their grandchildren. Despite of all of this, there are some grandparents that are denied visitation and quality time with their grandchildren every day, even in cases when grandchildren desire to spend time with them as well. When grandparents are kept away from their grandchildren, it is the grandchildren who ultimately lose out on these important advantages. I would like to state that in no way am I looking to give grandparents equal rights or a status. I'm just simply looking for a resolution to build stronger families without having grandparents be excluded from their lives, from the lives of their grandchildren. I think this work group will do just that. And therefore, I ask for a favorable report for House Bill 1195 with the amendments to make this legislation a work study. Thank you for your time.
Thank you very much. Let's go ahead and hear from those testifying in favor. Laura Nickey, Vince McAvoy, Eric Smith. We'll hear from them. We'll hear from them for 2 minutes each. Let's see. Laura Nickey. Laura Nickey.
I'm on mute. Hello.
Great. 2 minutes, keeping in mind that the sponsor has indicated that she wishes to create a work group. Laura, go ahead for 2 minutes.
Hi, my name is Laura Young Nickey. I am the former president of Fathers United for Equal Rights of Maryland, Linthicum chapter. No, I'm not a father, but every other state in the United States has some form of grandparent visitation rights. And from what I've read, Maryland law is badly flawed, making it difficult to win visitation. I am a victim of this. I've been working with Chanel to provide more information from Alienated Grandparents Anonymous, which is a nationwide group. It's basically an epidemic, grandparental alienation. It stems from parental alienation, which I was the victim of in my divorce, and my daughter was also, and it should stop with this generation now. Delaware has laws regarding third-party visitation and language that includes grandparents. Pennsylvania covers grandparents under laws referring to persons of legitimate interest. And West Virginia provides for visitation so long as it's in the best interests of the children and does not interfere with the parental relationship between the grandparent and the parent. I have not seen my grandchildren since 2019. There has been no reason given why. I was taken to court basically for showing up at a volleyball practice that I thought was a game and filed charges for stalking. Well, if stalking is sending flowers and putting a birthday card and a balloon on the basketball hoop on the sidewalk, I think a lot of grandparents are guilty. My granddaughters love me. They said they wanted me to still be part of their life. No one will tell me why I've been shut out. I have sought support with Alienated Grandparents Anonymous. A lot of people are in this situation. I know 4 personally offhand, and I plan to start a chapter in Maryland. And I think a committee would be good to evaluate personal circumstances in each case, because it is not always warranted by the parent, not in the best interest of the children.
Ms. Nickey, I'm sorry, I need you to wrap up, please.
Okay. I just am in favor of support of the House bill, and I hope that everyone realizes it's not unconstitutional, as was stated in last term. Thank you.
Eric Smith, please, for 2 minutes.
Yes, I don't have too much to say because as I look at the current law of 9-102, it just gives permission for those grandparents if it's put in. And we here with, I'll say, the winning strategies, we try to encourage those grandparents who want those rights to put it in. And if any of the, I'll say wording from Delegate Shoemaker's, Delegate Branch, and Delegate Adams' bill has the opportunity to strengthen this bill, I'm all for it, because actually grandparents do need access to the children as well. Thank you.
All right. Are there questions for the panel? It appears Mr. McAvoy is not here. Okay, seeing no questions, that's fine. We thank you both very much for your testimony today. Might be hearing from you a little bit more, but that's totally fine. We'll call you back in for the next bills. We have one person testifying in opposition, and that is Michelle Smith. We could have Michelle Smith brought in, please. We'll hear from her for 2 minutes. All right, Michelle Smith, if we could hear from you.
Thank you, Mr. Chair. Welcome back. I am here, Michelle Smith, on behalf of the Maryland State Bar Association Juvenile and Family Law Section Council. I have had the privilege of working and communicating with Delegate Branch on this bill in particular. My remarks from the Section Council will apply to all 3 bills. I don't know if you want to call me back each time, just so they're recorded. We did file written testimony that's exactly the same. But I have spoken to Delegate Branch. I have not had the opportunity to see the amendments, but based on what she has testified to regarding establishing a work group, myself, as well as I think at least one other members of the Section Council, my co-chair, as a matter of fact, would be interested in working in tandem with her on that work group in order to try to get a bill that could pass constitutional muster with regard to grandparent access to their grandchildren. We all know this has been a perennial bill, and I have testified on this in previous years for the Bar Association. There are very, very strict constitutional rights and substantive presumptions that it is in the best interest of children to remain in the custody and care of their parents, and therefore expanding or broadening our current 9102 section that applies to grandparent visitation cannot be separated from a broader concept of third-party custody, which we would like to tackle in that work group. Those cases are winding their way through our appellate system right now. And it seems like each year there's more and more information from our appellate laws with regard to what it means to be a de facto parent and third-party custody. So that is a work in progress, and we need to keep our fingers on the pulse of that and have legislation that corresponds to what's happening with our case law, not just in our state, but we are also looking across at other states. So right now it's an unfavorable report because I have not seen or had been able to show the amendments to our section. Thank you.
Thank you very much. Are there questions for Ms. Smith? We are going to ask you to come back. That's just the way we need to do it with each of the bills, so it's fine. Any questions for Michelle Smith? Seeing none, we thank you very much, and that concludes the testimony on House Bill 1195. Delegate Adams is here. He has a House Bill 1141. I will say, my understanding is that Delegate Adams has brought in the bill based on a request from a constituent. So that's perfectly fine. It's why we're here. So we're going to hear from them in a moment. So if I could have, I don't think Vince McAvoy is in the room, but Yvonne Stinchcomb, if Yvonne Stinchcomb could be brought in, that would be fine as well. We'll hear from you, Delegate Adams, and then we'll hear from Yvonne Stinchcomb, please.
Okay, thank you, Mr. Chairman, and I'm happy to present the bill by request of a constituent. I'm glad to see there are a few bills on this. You know, it's out of my depth. I'm in business regulation and commercial law. So with that, HB 1141 is a bill that requires an equity court to consider specified factors when determining if it is in the best interest of a child to grant visitation rights to a grandparent. Specifically, the court must consider, number one, the amount of personal contact that occurred between the grandparent and the child before the filing of the petition, including whether the child and grandparent shared a significant relationship for at least 12 months. Two, whether the child desires to have visitation with the grandparent regardless of the age of the child, and 3, whether the grandparent was unduly denied visitation by the child's parents. My constituent Yvonne Stitchcomb has asked me for a couple years to bring the bill in. I had it go through rules a couple years ago and missed my opportunity, but I know that she's very happy to be with the committee today and share her testimony, which I've heard myself, and it's very compelling. And thank you for the courtesy to be with you today.
Thank you. Delegate Adams, interestingly, we don't see Yvonne here. We do, however, have Vince McAvoy. So what we're going to do is ask Mr. McAvoy to come in the room, and maybe if you want to send Ms. Stinchcomb a text to see if she would get on the call.
I'll do that right now.
Yeah, that's fine. So we'll hear from Mr. McAvoy for a couple minutes, and then we will do that with the hope that Ms. Stinchcomb will come into the waiting room, and then we can go from there. Mr. McAvoy for 2 minutes, please.
Thank you, Chair and Committee. I understand we're looking at 3 of these. I heard your audible, Chair, and I appreciate that. Not knowing where these go, right? Sometimes we've had sort of one-offs and they just sort of died on their own in previous years. We all know that that there are accommodations that need to be overcome. As I'll be speaking, and I apologize for missing Delegate Branch's bill, as in Ways and Means, that having that committee to look at those and feed it in with the other requirements that we have in family law is necessary. But what Delegate Adams' bill does do is he iterates some of the things that should be considered, because as we think about these cases in the city, well over 20% of our children are being raised by grandparents in the city. This is a very pertinent bill. And when you're looking at that we have a significant relationship, that really needs to be considered. This also helps to lessen parental alienation, helps focus on the team spirit of raising that child as maybe they're undergoing hurdles, and that's why it's frequent the case in the city why they're having that type of setup as opposed to the 2 biological parents raising the child. The issue about unduly denied visitation, I know that it's going to get into a tough area. I'm sure you all are going to consider that, but I just did want to encourage all 3 bills that you're hearing today about grandparents. I do think it's time. I think that in previous years, I was very concerned about it eroding parental rights, specifically those of the father. I think that we are suffering such a family breakdown in this state, in this nation, that we really need to delve into this and see what we can make work. We all have experiences with our grandparents that we love. They were great experiences, and we shouldn't deny our children coming up those type of experiences. Thank you for your time, committee.
Thank you. I believe that Yvonne Stinchcomb is now in the waiting room, and we're working on it right now. We'll give her the opportunity to get in, and we are working on that.
Mr. Chair, I don't think I can help much further with this. If you want to proceed, and I'll try to.
You're fine. I mean, we'll certainly. I certainly want to give her the opportunity to speak. I know that she requested the bill.
Yeah, I'm going to go back on mute and try to call her one more time. Thank you.
Okay, that's fine. Staff, Will Shorter.
Mr. Chair, do we know if the witness is trying to come via iPhone?
Let's try.
I'm finding. Yeah, I would say try it out. That's probably right.
Thank you.
This could be fun. All right, let's see if Yvonne Stinchcomb, are you there? You're going to have to unmute yourself if you're there. Yvonne Stinchcomb.
Yeah, Mr. Chairman, I think we've tried our best here. She and I are communicating with the cell phone, but she says she's in a waiting room. She sees a waiting room.
That's fine. I mean, I don't know. Look, if we could have Michelle Smith brought in, she's in opposition, but we'll hear from her, and if somehow we manage to get her in, then we'll go from there. If we could have Michelle Smith in the room, that would be fine. Ms. Smith, again, in opposition to House Bill 1141. We may have the person who asked Delegate Adams to put in the bill here in a moment, but Ms. Smith, go ahead for 2 minutes.
Hopefully I can use up some time so she can get on.
That's right.
I'm Michelle Smith on behalf of the Maryland State Bar Association Family and Juvenile Law Section. With regard to House Bill 1195, we are currently recommending an unfavorable report, and that's only because with grandparent legislation that we currently have in Section 9102, the broadening of those rights for grandparents to seek visitation as well as custody has got to be done in a very comprehensive manner so that it can withstand constitutional muster, as well as draw in the other third-party custody issues that our appellate courts are struggling with right now and giving us guidance on. So if there's a possibility to establish a work group, members of my section would be proud to be a part of that work group. We do definitely understand what grandparents have gone through in some cases where they have been denied visitation or custody with their children just based on our current state of the law. And with that, we would urge an unfavorable report to House Bill 1195, and hopefully there will be a work group established through another bill. Thank you.
All right. So it's a little bit unusual because we have people on both sides, and I'm sure we'll work through it. But Delegate McComas has a question, and so we'll take Delegate McComas's question. I just ask you to direct it to who you'd like to direct it to.
I'm going to, thank you, Mr. Chair. I'm going to direct this to Ms. Smith. I've practiced law and I've had domestic cases, and I think that it's a civil rights issue for kids. And I'll tell you where I'm coming from. I think kids have a right to know their heritage, their relatives. And I've seen the spite factor of a parent. They'll say, there ain't no way in hell you're going to see the grandkids. And it's a way to really put a knife in the heart of the grandparents. And it's not done for any noble purpose. It's just they don't like them. And it's a power and control issue. So I guess what I'm wondering is there any room in the authority of parents that the child has a right to know its extended family? If they're not criminals and they're not bad people? I mean, I just think the kids are missing out. So can you answer that?
Delegate McComas, thank you. That is a very good question, and one that I would like to consider in a work group, because the civil rights issue of the children, really, I have not seen literature that has focused on that, because the constitutional right of the parent to have unfettered decision-making rights regarding their children trumps everything, including perhaps the rights of the child to know their grandparents if, like you say, they're otherwise fit. So that is a different tack to take and a different analysis I'd like to take across the states to see if anybody else has had success in that, pursuing that avenue.
Okay.
Mr. Chairman, I would just encourage the committee to look at written testimony that Yvonne has submitted, and in return, I'll let Yvonne know that there are 3 bills that seek to resolve her concerns. And thank you very much for the opportunity to present the bill.
I wish you would let her know that we will certainly look at her written testimony, and that you will also let her know that there is this issue has been before us several times before, and it appears that there may be some interest in a work group, but we'll see where we're going here soon enough. Okay. Thank you very much. I think with that, that concludes the testimony for House Bill 1141. Now Delegate Shoemaker has his first of two bills. The first on grandparent visitation. And so we'll hear from his panel, and that's Delegate Shoemaker, Linda Stolkovich, Donald Stolkovich, and Eric Smith. Also, Vince McAvoy has signed up to testify in favor. So we'll start with Delegate Shoemaker here for 3 minutes and then go from there.
Thank you, Mr. Chairman. This is a piece of legislation like the one that Delegate Adams introduced a moment ago that I bring to this committee in response to a very sad story from the Stolkoviches who are on my panel. They'll be able to testify a lot more eloquently than I can about the circumstances that they've dealt with. But essentially what my bill does is it seeks to add clarity to the circumstances in which a court may permit the awarding of visitation to grandparents. It says that a court may award visitation rights to grandparents if, of course, both of the children's living parents consent, one of the child's living parents consent to visitation, the other parent is unable to consent, or both of the child's living parents are unable to consent, or fourth, there's some kind of exceptional circumstances that exist that demonstrate current or future detriment to the child absent visitation with the grandparent. So this is clarifying. I believe that it is notwithstanding the objection that you may hear in a few minutes, I believe it passes constitutional muster. I think that it's compatible with the decisions from the Maryland Court of Appeals and the Supreme Court of the United States. And with that, I would defer to my panel, the Stolkoviches, so that they can tell their story. Thank you, Mr. Chairman.
No problem. Let's hear from this. They're not in the room yet. Let's hear from the Stolkoviches, please, and bring in Eric Smith and Mr. McAvoy. Let's see Eric Smith. Well, we have the Stolkoviches. Oh, we do have somebody, yes. Mr. and Mrs. Stolkovich, please. Going to have to unmute yourself.
Can you hear me now?
Yes, Mr. Stolkovich, you and Linda have 2 minutes each. So we'll go ahead and hear from both of you, all right? What I'll do is I assume you're both there at the same computer. So I'm just going to give you 4 minutes altogether and you can split it up any way you'd like, all right?
I'm still actually at work, sir, so we'll let you go first.
All right, well, then we'll hear from you for 2 minutes. That's fine.
All right, my name's Don Stolkovich. I live at 2255 Gulf View Lane in Hampstead, Maryland. This is the third time my wife and I have testified in regard to grandparents' rights. It's very upsetting coming down here for the third time that Maryland supposed is the progressive state. And there's nothing being done for grandparents' rights here. There's many other states in the United States that have grandparents' rights. And I don't see why we can't have something here. Every time there's a illegal alien issue that comes up, it seems like we fall over backwards to help them out. But yet, tax-paying citizens of Maryland, I pay a heck of a lot of taxes, $6,000 a year, which is a lot. And nobody's out here to help me and my wife to see our granddaughter. We haven't seen her in over three years. That's a long time. I just don't understand it. I don't understand it at all. I constantly hear it's, well, once the Supreme Court says it's okay, then they'll let it go. But why do other states have it? Why can't we have it? It's just, I just don't understand it. What's the difference? I let my wife take it from here. I'm just a very disgusted taxpayer.
All right, we'll see if Ms. Stolkovich is here. I don't see her in the Zoom room just yet. And so we're hopeful that she's going to be able to join us here. So what I'm going to do is I'm going to go to one of the other people who are here to testify, and we'll keep an eye out for her so that we can add her into the Zoom call. We'll go to Eric Smith. So just hang on right there. Hang on. Don't leave us yet. Eric Smith, please, for 2 minutes.
Yes, I say I'm in favor of this bill for, again, 2 reasons. My son has been help for me and his grandmother for no reason. And the mother continues to use him as I'll say, a ploy for other reasons. Now, if this is happening with my son, I know it's happening with other children and to other parents. I'm currently trying to help another grandparents that had asked for how can they get access to their grandchild and keep their grandchild since the mother is away. The mother doesn't plan to come back from Atlanta. I say, well, you can go talk with a lawyer to ask them to get your guardianship rights and while you're trying to get your grandchild back here in Maryland. However, I feel I'll say more needs to be done for grandparents to have them have access to their grandchildren so they will not be without them for a long period of time. Thank you.
All right, we're going to go to Vince McAvoy for 2 minutes, and we're still trying to find Ms. Stolkovich. Please, Vince McAvoy.
All right, thank you, committee. And Mr. Stolkovich, I remember talking with you and your wife outside of the judiciary hearing room some years ago, and this is a tragedy that this has been going on so long, and as Delegate McComas just brought up, and is the spirit of the bill that Delegate Shoemaker's brought, that we have consent issues because we have grandparental alienation, because we have bickering, because, and I know your case because we spoke, I think the word you used was evil when we talk. I mean, if memory serves, and it's just wrongful. It's wrongful because I met you and your wife, you darling people, and these are the type of deprivations that are going on with our children needlessly because we're not enforcing. And as I told the Stolkoviches at that time, we're really not enforcing the law as it exists today for parental rights. Because if we had, then they wouldn't be having the problems. But we see that it's gotten so out of hand that we actually need to sort of approach it from the other end, from the downside. As opposed from the children to the parents and up, that we can have some type of balance and kindness, because we don't have that. And so I'm very much in favor of this bill. I'm glad that there's going to be a workshop to work through these things. And I think that those elements, the animosity, parental alienation, the lack of kindness for the children, that all needs to be considered. And Delegate McComas, tip of the hat for your aspect as far as civil rights. Children deserve to know their lineage. Thank you so much.
All right, we're going to try again, and I think we have her now. So let's go to Linda Stolkovich, please, I believe. Or is that you?
Hi, yes. Can you hear me now?
Excellent. We can. For 2 minutes, please.
Okay, great. As you know, this is the 3rd year that we have testified. And in fact, the last time that we testified, we did a written testimony. Well, unfortunately, we got repercussions from that because the parents saw it online and he decided that he was going to file charges and all kind of repercussions just because we were trying to get a grandparents' rights. Now, it's been 7 years that we were actually involved with our grandchild. And just because he decided that he did not want to us to be a part of her life, then we're not able to see her. This is not good for our grandchild. It's not good for relations. And we need to know what we need to do for this bill to get it to pass. Whether we need the one that was rejected last year, they said because it said that the exceptional circumstances or unfit. Well, the problem is with that is it's very hard for either one of these things for us to, prove that. So what it is we need something that says best interest of the child. We need something that that we can get some kind of intervention with the courts that will say that they can either do an ad litem, do therapy, do something to make the parent, because he does not want us to see the child and there's no reason for it. It's detrimental to the children. We had so much involvement in her life and now we have nothing just because he has an axe to build and it's just not working. We need help. What can we do to make this bill a little better so that we can actually get something going with this bill?
All right. We've heard from the witnesses now. Are there questions for this panel?
Sir, can I say one more thing?
Briefly, sure.
Yeah, Don Stokovich again. I work in Baltimore. I'm working on 3 different bridges off of the BW Parkway. But I tell you what, it's sad. I see little kids running around, not now, but in the summertime, and I'm sure they could use their grandparents' love and to hold them and love them. Maybe we wouldn't have some of the crime problems in Baltimore that we have if they had somebody to bring them up and nurture them like they should be. Thank you.
Are there questions for the panel? All right, seeing none, we thank you very much for testifying, and we're going to go now to the testimony in opposition.
Thank you for your time.
Thank you. From Michelle Smith. There is Michelle Smith. This is on 943, please, for 2 minutes.
Thank you. I'm Michelle Smith on behalf of the Maryland State Bar Association Family and Juvenile Law Section Council. As I've testified about the previous 2 bills, House Bill 943, we are urging an unfavorable report, and that is simply because we want to make sure that any bill regarding broadening grandparent visitation access or even custody to their grandchildren would be able to pass constitutional muster as well as be in compliance with our current appellate law in the state of Maryland. And our section would be happy to be involved in a work group to try to make that happen. I did hear the testimony from the Stokoviches, and I've heard it before. It is, I've heard the details of it in prior years. It is very sad. And there are members of our section who have litigated similar cases and been frustrated by the fact that the Supreme Court has said that the biological parents have constitutional rights to care, to the care and custody of their children that trump everything else, and that they have to be basically proven unfit, or you have to prove exceptional circumstances in order for a third party, including a grandparent, to have access or custody granted by a court. And we want to make sure we're in compliance with those laws so that we don't pass legislation that will be undone. So we would support being involved in a work group, but unfortunately we have to urge an unfavorable report to this particular bill, House Bill 943. Thank you so much.
Are there questions for Ms. Smith? All right. Seeing none, that concludes the testimony for House Bill 943, and we thank you very much for that. We're going to go now to the last bill of the day, House Bill 947. Again, Delegate Shoemaker for 3 minutes, and then we'll hear from the witnesses in favor. Joseph Dumonchel, Rachel Endo, Eric Smith, and Vince McAvoy. So Delegate Shoemaker for 3 minutes, everybody else for 2. There's a panel in opposition, and we'll begin with Delegate Shoemaker now for 3 minutes.
Thank you, Mr. Chairman. We know under Maryland law that the state Equal Rights Amendment of, I think it was like 1972 or something, despite what Delegate Buckle said, I was a little kid at the time, but in any event, for approximately the last 50 years, at least, there has not been a maternal preference in connection with child custody cases. However, and I've seen it in practicing law for 30 years, where I've represented fathers and mothers, by the way, that there is a perception, at least, that there may, in fact, be, in a lot of instances, a maternal preference in custody cases. So basically what this bill does, it's relatively simple. It says that in a child custody case involving the parents of a child in which there isn't any allegation of abuse, there would be a rebuttable presumption that joint legal custody is in the best interest of the child, and two, that the joint physical custody would be for approximately equal periods of time, and that too would be in the best interest of the child. Now, of course, there's a child support component to this. I'm not particularly wed to this. I know that DHS, I believe, sent in a letter of information, which kind of read to me like a letter of opposition, but in any event, they called it a letter of information. But the child support component of this would be that essentially in a shared physical custody arrangement, there would be essentially a general charge of support, whereby each party, when they had the child or children in his or her care, they would be charged with the responsibility of providing support for the child, and essentially no money would be changing hands in those arrangements, all things being equal. So pretty much those are the components of the bill. And I will turn it over to the panel, Mr. Chairman.
Okay, let's hear from Joseph Dumonchel. If he's here, there he is. Let's hear from him for 2 minutes, please.
Well, my story is, I went through a custody battle when my son was 5 years old, and we're still currently in that battle. It's been going on for over 3 years. The last time I went to court was back in August, and I lost all my rights to my son because we had too much fun together. The judge states that because I take him fishing, because I have fun with him, that I must not have any structure. She is not allowing me to see my son, talk to my son. He can't call me. He can't contact me for the 2 weeks she has him. And to me, a father shouldn't have to fight to the brink of bankruptcy just to spend time with his son. My son is threatening to kill himself, to run away. He hates his life. I had proof of her being abusive. She smacked him. She drove drunk with him in a car, locked him in a cage with a rooster, and the courts didn't care. All they cared about was what gender I was and how much money I made. So I lost my son. This is why I'm here. This is why I want this bill should go through, that kids need both parents. They need the mother, they need the father. And a father that's got every other weekend is considered a fatherless home. And there's a lot of statistics on children raised in a fatherless home are more enticed to quit school, go to jail, get into crime and drugs. And I don't want that for my son. And right now, I'm fearing for his life because he's constantly threatening to kill himself, and she's got him on 5 different medications. So I'm very worried about him, and it's why I really need this to go through. So I guess I'll end that here.
Thank you. Let's hear from Rachel Endo, please, for 2 minutes.
Hi, my name is Rachel Endo. I'm the mother of 2 children who were abducted by their father to Japan, and I'm a volunteer with both the NGO of Keep Our Kids Home and Find My Parent. And thank you for the opportunity to share my story today. I'm here to express my support for House Bill 947, Family Law Joint Custody. I have personally witnessed and continue to struggle with the ill effects of sole custody What is even worse is the negative effect it has had on my two young daughters. It is because of this I continue my advocacy to change sole custody laws in Japan and the United States. So to share my story, in February of 2019, my husband and I litigated custody, and I was awarded full physical custody and joint legal custody of my daughters in the United States. My husband wanted to take our daughters on visitation to his native Japan, but because to date, Japan does not recognize joint custody and fails, to date, Japan does not recognize joint custody. It facilitates the ability to return the children, and he failed to return my children. They were abducted. I tried to take the matter to court in Maryland, where a judge ruled that my husband could indeed take the girls on their visitation to Japan, even though I pleaded with the judge to consider how sole custody laws would facilitate the kidnapping. My worst fear became reality when my husband refused to return my daughters home to the United States and cut off all ties with me. It was because Japan only legally recognizes sole custody that my husband was able to get away with this. Had joint custody laws been in place, my daughters would have been safe and had access to both parents. I was lucky to win a habeas corpus case in in Tokyo High Court, and my daughters were returned to me, which rarely ever happens, especially for foreign parents in Japan. However, the socioeconomic and psychological effects the situation has had on my daughters and I and on our lives is something we continue to struggle with today. Miyu and Amane were taught to hate me and America and to hate their half of their identity and culture. Miyu was forced by her father to write a letter to the Japanese court stating why she hated me so much when she was just 8 years old. And she would write in her journal after I got her back about how she didn't want to write these letters and how ashamed and sad she was that her father had posted these letters on social media. It is because of the sole custody only system that my ex-husband was able to brainwash and manipulate the children. This, may be a case of international divorce.
I need you to begin to wrap up, please.
Okay. But my scenarios, such scenarios are not uncommon here when two Americans divorce.
Okay.
As long as joint custody is not considered the default in the best interest of the children, parents will continue to have long and expensive divorces and child custody proceedings, only causing harm to the children. That is why it is crucial for the state of Maryland to protect the best interest of children and ensure that joint custody is the default arrangement.
Thank
as long
you.
as the child is not in danger.
Thank you. Thank you very much. 2 minutes now to Eric Smith, please.
Yes, I'm in favor of 0947 for custody to be joint at an initial case. Reason being, like I said, I deal with fathers who are victims of this, victims of the court system. Okay, you go into a case initially hoping to hear how they will give you joint physical custody. However, it's sole custody to the mother. And it's questionable how can you give sole custody to the mother when it's an initial case. So therefore, I encourage the fathers to either put in for a modification or take it straight to COSA, the Court of Special Appeals, and tell them how the judge very well violated procedural law. This is happening, I'll say, rampant in Baltimore City. It happens rampant in Baltimore County. This bill, I'll say, gives us fathers the right to have access to our child, to have access to our children. My case is like Mr. Joe's there. Okay, I've had my son. Then all of a sudden, one of the judges in Baltimore City violated my rights, and basically right now I have my case at COSA that's supposed to be heard this month, okay, because the judge violated rights. And I make sure that was made known, and a lot of fathers are dealing with this, and it has to stop. It has to stop now, because like Joe said, the mothers sometimes put children on a lot of medications that they don't need to be. only because Title 4D allows them. Thank you.
Vince McAvoy, please, for 2 minutes.
Thank you so much, committee. This is an extremely important bill. I thank Delegate Shoemaker for bringing this bill. This present state shows that there's a rebuttable presumption. Of course, you all know about rebuttable presumptions. They can be overcome, and they often are. That's not the issue with the case. What we're looking at with this bill is an ability for you, as I mentioned in a previous bill, to check the Maryland judiciary. Since the time I've been coming to Annapolis, I've been explaining that cases that you've heard today and that you've heard over the years are happening all the time. And it's the legislature's job to step up and check them. Several years back when Joe Valerio was in, I cited an actual case where I actually combated with a judge and got a ruling against them, and yet he's still practicing law in Baltimore County. It's amazing. See, so there's no checks that are effectively happening on this. Now, you've never heard me advocate for bad parents. You're not going to. But when we have good parents who are being denied the love and society of their child, and that child is missing out on that love and society as well, it's harmful to justice, it's harmful to family structure, and it's wrongful, and that's why you all need to stand up for this. Any number of ways that we can show that this is the fact, and that getting justice in our courts is an exception. It's not the rule. If we were to say that only 10% of the people that went into criminal court got justice, there would be hollering and shouting. Okay, but here we're looking at a situation in Maryland where basically 6 out of 7 placements have a routine cookie cutter setup with maternal preference, and this is ensconced in our code in Maryland. This is not like some conspiracy theory. This was written up to 1973. So again, I implore you all to act on this bill, to check this. I'll be sending you data that supports what you've heard in testimony here. But this is a vital bill. This is about the very fabric of society in Maryland, which is being ripped apart. And you have the ability, you all now have the ability to stop this. So I thank you, committee. I thank you, Chair, for setting all these bills up. Thank you so much.
Thank you. Are there questions for this panel? All right. We don't see any questions for the panel, so that's fine. We thank you very much, all of you, very much for your time to come and testify on House Bill 947 today. And we'll now go to the opponents: Dorothy Lennig, Laurie Ruth, Melanie Shapiro, and Michelle Smith. All right, I see Dorothy Lennig. We'll go ahead for 2 minutes with Dorothy Lennig.
Thank you, Mr. Chairman, Mr. Vice Chairman, members of the committee. My name is Dorothy Lennig. I'm the director of the legal clinic at the House of Ruth. I'm here today to urge an unfavorable report on House Bill 947. In 2013, the Maryland General Assembly created the Commission on Custody Decision Making, and it brought together really an important group of people. It was lawyers, family lawyers, judges, magistrates, psychologists, domestic violence advocates. I sat on it, fathers' rights advocates. And ultimately, after the committee met for, I think 2 years, Delegate McComas was on there with us too, as was Laurie Ruth and others. The ultimate decision of the group was to recommend against creating a presumption of joint custody. And many people on this panel today will talk about the reasons why. The problem that I see is that HB 947 refocuses the current custody standard, which is where the court looks at what's in the child's best interest, to create a presumption of joint custody. So I think you have to think about the cases where judges actually make these decisions. These are the most contested cases. Most cases settle. So the only ones where judges are actually making the decision are the ones where the parties just can't figure it out at all. And these are often the cases where joint custody just really doesn't work because the parents can't work together in making decisions that are good for the children. Judges currently have the authority to order joint custody if it's appropriate, but it forces them to look at the family. As we know, each family is different, children are different, circumstances are different, resources are different, and we want the court to take the time in each custody case and really review and think about what's the best thing for these children. These are not one-size-fits-all cases. So let's maintain the best interests of the child standard. Let's not move to a cookie cutter approach. And I'm urging an unfavorable report on House Bill 947. Thank you.
Thank you very much. We'll go to Lori Ruth now, please, for 2 minutes. You're muted.
Yes, excuse me. Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. I apologize for my camera. I'm using backup technology because my primary technology failed today. I am the legal director at the Women's Law Center of Maryland, and I'm here also to urge an unfavorable report on House Bill 947. I'm going to focus primarily on the child support aspect of this. The one thing I can agree with Delegate Shoemaker about is that the Office of Child Support's informational testimony actually reads like opposition, but you really need to take note. They explained that this bill would eviscerate, it would actually get rid of the income shares model of our child support guidelines. And the income shares model is what our guidelines are based on. Without us doing that, we have the potential of losing, I did the math, although they break it out for you, $350 million in federal funding. So the Section B of this bill the consequences cannot be overstated about how damaging it would be to really the entire state of Maryland and all of our citizens. So I urge you to read their testimony. And the part I also want to focus on also about child support is if we did what Delegate Shoemaker's bill wants, the parent earning $100,000 a year or $500,000 a year or $1 million a year would be paying the same amount of child support as the parent earning $20,000 a year or $10,000 a year or on disability payments, because they would be charged generally, and there would be no equalizing of the households to maintain a standard of living for the child that they should have. That is the fundamental basis of our child support in this state. And this would completely upend that in every way. So for the reasons that Ms. Lenig mentioned, I was also on the commission. Ms. Shapiro, who you're going to hear from, and I were on the Child Support Review organization 4 years ago. And these committees are formed by knowledgeable, intelligent people and national experts. So for those reasons, we oppose this bill. We urge an unfavorable report. Thank you.
Thank you. Melanie Shapiro, please, for 2 minutes.
Good afternoon, Mr. Chairman, Mr. Vice Chair, and members of the committee. Melanie Shapiro, the Maryland Network Against Domestic Violence, here in opposition to House Bill 947. Wanted to discuss the preclusion that for cases in which there are allegations of abuse. And I apologize, my children just came home from school. If you 1 minute.
1 moment, please.
The beauties of working from home. So the reason why we are concerned about this is because there is an exclusion already in screening out that occurs for mediation processes and for victims of abuse. And unfortunately, it's not a perfect system. And there are still people who find themselves going through the mediation and the family court process that they shouldn't otherwise be going through. And we have a lot of self-represented individuals in the family law context. And so they might not even know to ask for sole custody with this type of presumption. And so it's such a disservice to victims of abuse who might not even acknowledge or disclose their abuse also, because it is something that's very private and personal, and people experience a lot of embarrassment as a result of it and don't disclose it. And so this could be very harmful and damaging to all of those individuals. And so for those reasons, as well as the others testified to already, we are asking for an unfavorable report on House Bill 947.
We welcome everybody home from school. Michelle Smith, please, for 2 minutes.
Thank you, Mr. Chair, Mr. Vice Chair, and members of the committee. I'm here on behalf of the Maryland State Bar Association Family and Juvenile Law Section Council. We urge an unfavorable report to House Bill 947. I would encompass in my comments, which are already in my written testimony, all of the comments made by Ms. Lenig, Ms. Ruth, and Ms. Shapiro. So I'm not going to repeat them other than to just highlight that the best interest of the child standard under the factors in Taylor versus Taylor and Montgomery County versus Sanders, as well settled law in our state, have got to be the analysis in child custody cases. The burden shifting that occurs in rebuttable presumptions is confusing even to lawyers. So we have a concern that unrepresented litigants, of which there are thousands in our state, are not going to understand that it is a rebuttable presumption for joint custody and that they must rebut it. And then what happens when they do rebut it? Do we refer back to our standard factors? The burden of persuasion remains on the original party. Is that going to be understood by unrepresented litigants? It's confusing at best. We should keep the focus on best interest for children. And regarding the child support section, this is of grave concern to our section. I would encompass the comments made by Ms. Ruth and the written information by DHS that this has disastrous financial effects for our children in households where the incomes are different, and the order would be for joint custody. So for those reasons, and one more actually, with regard to the child support, some members of our section have pointed out that this could result in further litigation, more litigation, unnecessary litigation with parties who take advantage of the idea that they won't have to pay child support if they just get 50% custody, which they don't even want. So we have seen that before when we, in our child support guidelines, and we have mitigated the cliff effect. And so we would ask that you give an unfavorable report to this House Bill 947. Thank you.
Thank you very much. Are there questions for this panel? Any questions? All right, seeing none, we thank you all very much for testifying today, and that concludes the testimony on House Bill 947. That concludes the testimony for us today and this week. We will not be having a voting session tomorrow, I would anticipate voting session or sessions, plural, to next week, but we're working that out. Please be aware of that. So we will be back here in committee on Tuesday next week, Tuesday, March 1st, 1 o'clock. So we thank you all very much, and we will see you next week. Bye-bye.